And I should just say I'm dialing in from Brisbane, Australia, and would like to acknowledge the traditional custodians of Brisbane, being the Jagera and Turrbal people, and I pay my respects to Jagera and Turrbal elders past, present and emerging. And I also apologise for any of the Currawong bird calls that you can hear in the background. Apparently they're talking about food. So anyway, so this webinar really aims to start a vital conversation considering trends, best practices and challenges related to ECTs in Asia and the Pacific. And to put it into perspective about why that's so important, it's worth remembering that more than 60% of the world's population lives in Asia. And in 2020, the region accounted for 52% of global greenhouse gas emissions. The region is also home to 17 of the world's 36 biodiversity hotspots. So that makes Asia and the Pacific central to international efforts to protect biodiversity, the environment, and the climate. Now, the world is also starting to grasp the transformative power of the environmental rule of law and its critical role in supporting the transitions that need to occur in the coming decades if we are going to limit climate change, pollution and biodiversity loss. In their joint workshop report from 2020, the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, IPBES, and the Intergovernmental Panel on Climate Change observed that improved implementation of international and domestic environmental law is an essential prerequisite for protecting the environment and reducing biodiversity loss, and in the interests of the public and future generations. Likewise, the IPCC recently observed the importance of legal frameworks in achieving global climate goals in the sixth assessment report, and so that means that ECTs are really central to the environmental rule of law and transformative change. But the issue is that we find ourselves in unprecedented times, and that requires us to all change at a pace at which we are unaccustomed, particularly in the field of law. So except for some major leaps, the law generally follows tweaks and well-established precedents. Furthermore, adjudicating the contemporary crises of climate, nature, and pollution is also hyper-complex, with diverse and sometimes unknown stakeholders. So in this modern age, judges now need to understand technical science and grapple with the rights of these emerging sets of stakeholders, like the environment, ecosystems, and Earth's non-human species. Additionally, judges are really being pressed to adapt the law to respond to these unprecedented challenges. And these shifts require resources, knowledge, technology, and new business methods. And that's why ADB is here supporting this webinar today. ADB believes that justice and our planet benefits when we provide forums for judges to exchange ideas. Furthermore, we believe that investing in ECTs and judges is critical to sustainable development. So we're really delighted to be part of this project, which leads into a book project, and hope, though, that at the core of our discussion today and the work that we do, we each reflect on this really critical point. How might this work contribute to the greater effectiveness of ECTs in Asia and the Pacific? Because that's really the work that needs to happen. So thank you so much. Welcome. I would like to welcome Matthew Baird, Director of ARIEL, to the floor to deliver his opening remarks. Matthew, over to you.
Thank you very much indeed, Briony, and thank you, Jolene Lin, for those very kind words of introduction. I'm Matthew Baird. I'm the Director of the Asian Research Institute for Environmental Law, and I'd like to also acknowledge Rocky Guzman, the Deputy Director of ARIEL, who is with us today. And as both Jolene and Briony have said, this sort of webinar today is about producing a book. I mean, and the chapter authors, prospective chapter authors, have focused their attentions on a number of particular issues, bringing together a whole range of expertise and diverse areas of competence in dealing with environmental courts and tribunals. Excuse me. But I should also point out that, as Jolene said, and as she presented at the recent IUCN Academy of Environmental Law colloquium in Brisbane on climate litigation, and as Briony has also identified, one of the important things that we are dealing with in terms of climate litigation, wildlife crime, waste trafficking and pollution is how the courts and other institutions respond to that. And the role of the courts is increasingly seen and recognised as being vital to ensuring that we survive these triple planetary crises that are confronting us now. It's important to note that this year, and in fact at the end of this month, the Land and Environment Court of New South Wales will celebrate its 42nd anniversary of its founding. And I acknowledge and pay tribute to the leadership of the Chief Judge of the Land and Environment Court, who is with us today, Justice Brian Preston. He and his fellow judges and previous judges on the court have demonstrated that environmental courts and tribunals can play a very substantive and formative role in a very challenging environment, the nexus between environmental decision-making and the environmental rule of law. It's also important to note that this year has seen the launch of the Montevideo 5 program of the United Nations Environment Program, where compliance and enforcement is one of the key areas that they will be focusing over the next 10 years. Because, as Briony also mentioned, access to environmental justice is a critical component. And this is where environmental courts and tribunals can play a very significant role, not only in terms of establishment, but also in terms of rules of procedure and how the courts respond. And indeed, I recall a presentation given by Justice Preston when he talked about the role that the Land and Environment Court had adopted and the opening up of the court processes to Zoom and online, I think it was Teams and online opportunities for people to participate during COVID. The important thing about opening up and allowing access to justice, and I will talk about that a little bit later when I talk about the rules of procedure in environmental law. But access to environmental justice is also broader than ensuring that we have appropriate forums like courts and tribunals. We also have to have the people, the lawyers, the plaintiffs that can bring those cases to the court. And I would at this point have also like to acknowledge Matthew Floro. Recently, Matt Floro from the Environmental Defenders Office in Australia was recently named the Young Australian Environmental Lawyer of the Year for his outstanding contribution and, as he pointed out in his acceptance speech, the contribution of his whole team and the Environmental Defenders Office in ensuring that people have access to environmental justice. Because the courts and the tribunals have to allow not only litigants, but the lawyers to be able to come before the court, plead them appropriately, and ensure that there is access to environmental justice in a real and meaningful way. We are at this point of time in a very interesting and exciting opportunity for environmental law with the recent adoption of the United Nations General Assembly on the recognition of a human right to a safe, clean, healthy and sustainable environment. The important work that is done by environmental courts and tribunals, the extraordinary collaboration that we're able to bring today is something that I find very exciting as a legal practitioner. When I first started studying environmental law in 1988, I believe it was, I had no idea where it would develop and where we would end up. I'd certainly like to thank Linda and APCEL for the extraordinary work that they've put into the update of the UN Environment Program Guidebook, which will be launched, and also to the work in Europe, Justice Lovers and others at the University of Ghent for preparing what is an exceptional update to the work of Professor Pring and Professor Pring. I hope you will also enjoy this exciting day today. I thank you very much for the opportunity to be here, and I look forward and at this point of time hand it back to Linda and show on for the next presentations. Thank you very much indeed.
Thank you, Matthew, Briony, and Jolene. Just for introduction, in terms of the book that we have already mentioned to those of you that are not familiar. So this book that we are talking about is a book on environmental courts and tribunals in Asia Pacific, which hopefully will be published by ARIEL in 2023. So what you have before you are all the panelists today, who are also our authors. Each person would write a chapter for the book, and then it will be compiled and presented to you. Hopefully, if everything goes into plan, in the middle or late semester, second semester of 2023. So this book aims to capture best practices, challenges, and way forward for ECTs, Environmental Courts and Tribunals, in Asia Pacific region. In particular, this book will attempt to explore various issues, including the likelihood of ECTs emerging in Asia Pacific countries, which currently do not have them, or how countries without ECT handle their environmental cases, or whether the development of ECTs are potentially or politically influenced, and what specific factors prompted the proliferation of ECTs in specific areas or countries such as China, and many other issues that we will discuss in the books. So it will be very interesting book. I'm trying to sell it to you, even though we haven't written it yet. But hopefully with all the authors here, we have, as Jolene and Briony and Matthew has already introduced to you, we have various actors in the sector, in the environmental courts of tribunals. I will go alphabetically, so I don't forget anyone. The first one is Matthew Baird. Together, he will be writing with Rocky Guzman. Both are from the Asian Research Institute for Environmental Law. And then we have Briony Eales from the Asian Development Bank. We have Gitanjali Nainggolan from Northumbria University Law School. We have Mama Gertie or Griselda Mayo Anda from the Philippines Environmental Legal Assistance Center. We have Kokila Konasinghe from the University of Colombo, Sri Lanka. And we have Alan Webb from the Key Chambers, who will be writing together in a team of authors from New Zealand with Judge Laurie Newhook and Prof. Sari Warnock. We have Noriko Okubo from Osaka University, Japan. We have the Honorable Justice Brian Preston from Land and Environment Court of New South Wales, Australia. We have our esteemed PhD student, Pei Xuan Xiang, very dear to our heart. We wrote together our last book together last year. She's from Tsinghua University. I will also be writing for you. I'm working for APCEL and Gajah Mada University. And we also have Yu Hong Zhao from the Chinese University of Hong Kong as our lineup of our authors in this book. I would like to invite my co-editor for the book, Shroyon Mukherjee, to give you some background on this webinar. The floor is yours, Shroyon.
Thank you, Linda. Hi, I'm Shroyon Mukherjee. I'm a research fellow at APCEL. I'm a postdoctoral research fellow here. So just before I did my PhD at the London School of Economics, and my topic was on valuation of natural resources, so kind of a law and environmental law and economics project. Yeah, it's good to see a wonderful turnout here today. Thank you all for joining. Welcome, a very warm welcome to our distinguished speakers and to all our members of the audience. So Jolene, Matthew, and Briony have already spoken about the importance of ECTs. Linda has spoken about the book about environmental courts and tribunals, which Linda and I are co-editing, and which brings us, of course, now to this webinar, which is organized in partnership with ADB and ARIEL. So thank you very much, ADB and ARIEL, for all your work in putting this together. I'll mostly just talk you very quickly through the proceedings, what's going to happen next, because we've already covered the book itself and ECTs in general. So we're essentially having a plenary session, which means everybody is going to be in one virtual room, so to speak, starting with Judge Preston. So that will be moderated by Linda. So that's going to start just after I finish my introduction. After that, and this may be something that some of you are perhaps not familiar with, we have a breakout room system. So session 2 will be broken up into a panel A and a panel B. So these two will be running in parallel. So you'll, when the time comes, you'll see an option at the bottom of your screen where it asks you which group you want to join. Obviously, the panelists know which group they're going into, but for the rest of you, for the audience, or for the speakers who are not speaking in session 2 itself, you're very welcome to join either panel, or you can also switch back and forth between the panels, because the same switch which lets you pick which room you're going into will also let you pick which panel you want to join. So you can switch back and forth between panels. Finally, we'll all come back together into the same virtual room, so to speak. So you'll see a leave room option. So at the end of session 2, the breakout rooms system will end. We'll come back all together for session 3, which is the plenary moderated by Matthew Baird from ARIEL. I hope that all makes sense. We'll have short breaks in between. If you want coffee breaks or rest breaks, we will have breaks in between. And yeah, I hope you enjoy the session, and I hope you enjoy it as much as we enjoyed putting it together and organizing it. We're really looking forward to what all the panelists have to say. Thank you very much. Back to you, Linda, for moderating the session 1 plenary. Linda, you're on mute.
Yeah, sorry. Thank you so much, Royan. We will start with session 1 now. I'll be your moderator for session 1. We'll have it from 2:20 p.m. to 3:25 to 3:25 p.m. Singapore time. I would like to invite our first panelist. Sorry, let me pull out the bio here. Okay. So the first session will have 3 presenters. The first one is Justice Brian Preston. Welcome, Justice Preston. He will write the role of ECTs in delivering environmental justice, theory and practice for the book, and will introduce us to this idea. Justice Preston is the Chief Judge of the Land and Environmental Court of New South Wales. Prior to being appointed in November 2005, he was a senior counsel practicing primarily in New South Wales in environmental, planning, administrative, and property law. He has lectured in postgraduate environmental law for over 30 years. He is the author of Australia's first book on environmental litigation and 142 articles, book chapters, and reviews on environmental laws, administrative, and criminal law. He holds numerous editorial positions in environmental law publication and has been involved in a number of international environmental consultancies and capacity building programs, including for judiciaries throughout Asia, Africa, and the European Union. The floor is yours, Justice Preston.
Thank you very much. Right. So, excuse me, my croaky voice. I've picked up a bit of a cold, but it's not COVID, fortunately. So what I'm looking at is a practical issue. Matthew Baird spoke about ECTs and along with Briony Eales. But what we want to see is, do ECTs make a difference? And so one of the things I'm going to be looking at is, do they make a difference in delivering environmental justice? Now, a central purpose for all courts is to deliver justice for all. For environmental courts and tribunals, this includes delivering what we refer to as environmental justice. And I want to just unpack what we mean by environmental justice. And it has 3 aspects: distributive, procedural, and recognition. Let's start with distributive justice. Now, this is concerned with the distribution of environmental goods or benefits and environmental bads or burdens. We can think of it as substantial justice because it is concerned with this distribution of the environmental benefits and burdens. Who gets what? And environmental law establishes the legal framework within which these distributions of the environmental benefits and burdens occur. So when we think about what it means to give access to distributive justice, then it involves first giving, but also then upholding substantive rights to members of the community of justice to two things, the benefits and the burdens. So in relation to the benefits, to share in those benefits, to get the clean air, the water and land, to have access to green space or biological diversity and a healthful ecology. And as far as burdens, it means rights to prevent, to mitigate, remediate, or be compensated for the environmental burdens. Things like air, water, land, and noise pollution, the loss of green space, or loss of biological diversity and ecological integrity. So how can we achieve distributive justice? Well, obviously it's going to depend upon the laws themselves. And so when we look at the environmental laws, content and terms, we're looking for three aspects. Firstly, who is the community of justice? That is, who are the recipients of the distributive justice that's recognized by the laws? Next, what are the environmental benefits and burdens that are distributed by those laws? And thirdly, what's the criteria that is used in deciding what will be that distribution of environmental benefits and burdens under the laws? But law in theory is one thing, law in practice is a different one. So we need to actually see how the laws are applied in practice. Is there equitable or is there inequitable application? Or is there simply non-application of those laws that provide for equitable distribution? Now, the courts can't do too much about the first, that is the environmental laws, content and terms, but it certainly can do something about the second, and that's how the laws are applied in practice. My second concept of environmental justice is procedural justice. And this is concerned with the ways in which the decisions, including what I've just said, the distribution of environmental benefits and burdens, are made. And who's involved in making those decisions? Who has influence in those decisions? So we can see a link here between procedural justice and distributive justice. Because if we have broad, inclusive, and democratic decision-making procedures, then we're more likely to achieve distributive justice. But procedural justice can stand on its own terms. It's an element of justice in and of itself. So yes, justice does involve the just distributive outcomes, but it also involves just procedures by which those distributive outcomes are reached. So in order to achieve procedural justice, what do we need? Well, this time, rather than substantive rights, we need to give and uphold procedural rights to the members of the community of justice to first have access to environmental information, second, to participate in environmental decision-making, and third, to have access to review procedures before a court or tribunal to challenge decision-making or any impairment of those substantive or procedural rights that are needed in order to ensure distributive and procedural justice. My third aspect of justice is one which is not recognized too much, which is ironic given the title. So this is recognition justice. And this is concerned with issues of recognition of the various members of the community of justice. And I can group the injustice in three ways. First, non-recognition. That is where there is an ignoring of individuals, groups, or communities in that community of justice, so that effectively they're rendered invisible. Then there can be two types of recognition. And the first is misrecognition, where there's insulting or degrading or devaluing behavior towards certain individuals, groups, or communities. And the third is malrecognition, where there certainly is recognition, but it's malignant, and it's aimed at particular individuals, groups, or communities. And an example is the bringing of SLAPP suits, strategic litigation against public participation. So we can see that recognition injustice in any of those ways leads to inhibited or ineffective participation in the polity, so that's procedural injustice, but it also leads to inequalities in the distribution of environmental benefits and burdens, and that's distributive injustice. So how can we ensure access to recognition justice? Well, we need to ensure distributive and procedural justice. That is, we need to give and uphold substantive and procedural rights to members of the community of justice. But we also have to operate on those three types of injustice, recognition injustice. For the first, that's non-recognition, then we need to give recognition of individuals, groups, and communities, and I would suggest of the natural environment itself. As far as misrecognition, we need to prevent and remedy misrecognition of the members of the community of justice. And as far as malrecognition, we need to focus upon those particular methods of malrecognition, such as slap suits. So with that introduction, let me come back to what I started, that is the central function or role of courts is to deliver access to justice for all. And that means for ECTs to deliver environmental justice. And that, of course, is one of the justifications for having an ECT, that they do have the potential to deliver environmental justice more equitably, efficiently, and effectively than conventional courts. But what we want to explore is, has this potential been realized in practice? Are ECTs actually better at delivering environmental justice? Do some deliver environmental justice better than others? And if so, why? And so that involves looking at the particular characteristics of ECTs that might better enable them to deliver environmental justice. Now, in an earlier article, I think published about 2014 in the Journal of Environmental Law, published by Oxford, I identified 12 characteristics of successful ECTs. And I'll just quickly summarize these because I want to come back to them. The first is that the ECT has a higher status in the judicial system and authority. The second is that it's independent and impartial, independent from government and is impartial. Third is it has a comprehensive and centralized jurisdiction. I want to come back and explore this. The fourth is the judges, the members of the ECT, are knowledgeable and competent, what we might call environmentally literate. And I'll come back to that one as well. The fifth is it operates as a multi-door courthouse, offering multiple dispute resolution mechanisms. The sixth is it has access to scientific and technical expertise. The seventh, it facilitates access to justice, and here I'm mainly referring to procedural justice, but in this presentation I want to expand that to the other aspects of justice. The eighth is that the procedures are just, quick and cheap to resolve disputes. The ninth is that the court is responsive to ever-evolving environmental problems and hence remains relevant. The 10th is the court delivers environmental jurisprudence, and that's, I want to return to that because I want to see to what extent ECTs develop environmental justice. The 11th is that the court has a underlying ethos and mission. It is designed to deliver environmental justice. And the 12th is that the court is flexible and innovative and provides value-adding function. Excuse me for a moment. Now let's come back to those three ways of environmental justice. Can we group those characteristics to see if a court, an ECT, has those characteristics, will it better enable the delivery of environmental justice? So I've grouped those ones there by the number. You can see there are some common ones. So the first four, that is higher status of authority, independent, partial, comprehensive, centralized jurisdiction, and knowledgeable and competent judges, are common to giving all three types of environmental justice. Then we get some differences. So the fifth one, which is about multi-door courthouse is primarily relevant to procedural justice. The sixth one, about access to scientific and technical expertise, is mainly needed for distributive justice, that is, the distribution of environmental benefits and burdens. The seventh one, about facilitating access to justice, is there for all three, because we want to see all aspects of environmental justice delivered. The eighth, about just, quick and cheap resolution, is a procedural justice issue, so that's there. The ninth is responsiveness to environmental problems. Sorry, that is distributive justice. The 10th, about environmental jurisprudence. Sorry, just excuse me just for a moment. So the 10th I have for distributive and recognition justice, but I think it should also be there for procedural justice. The 11th is about the underlying ethos and mission that the courts are there to deliver environmental justice, so that should be there for all of them. And the 12th is about being flexible and innovative, and that's primarily for procedural justice. So sorry. So can I now come back to two of those? That is the third and the fourth, about the comprehensive and centralized jurisdiction and the judges being knowledgeable and competent. And so I can break those down into three core attributes that the court has to have if we are going to deliver environmental justice in those three ways. And I've grouped those by what are the roles of the ECT, the competences, and the expertises. So when we think about the roles, and particularly about the role to deliver environmental justice, I've found 5 roles. The first is coming back that it has to be ready to resolve those disputes equitably, efficiently, and effectively. Next, we have to have interest representation. This is about recognition justice and procedural justice. We need all those members of the community of justice to be able to have access to the courts and in decision making. There also has to be a forum for public discourse, not just a legal forum. And so this is raising those issues, and that's also got to do with recognition justice. And then we have to drill down to what are the values underpinning those environmental laws. We tend to think that adjudication is value-free. It's not. And there are those values, and we need to uphold those. And a lot of those values go to environmental justice. And we also have to implement the purposes of environmental laws. As I said, in achieving substantive justice or distributive justice, we need to uphold that fair and just distribution of environmental benefits and burdens. And they may be one of the purposes of environmental laws, and courts in it play a vital role in upholding that purpose. Let me turn to two things, competences and expertises. And I can divide competences into two types, constitutional and institutional. And when we think about constitutional competences, we're thinking about the role of institutions in a democracy, in a polity. And so that involves not only, of course, the 3 arms of government, but also the institutions in those arms of government. Now, for a court in the judicial arm of government, this involves understanding what is the proper role of the court in government and governance of the polity. And of course, that means we'll look at the separation of powers between the legislature, executive, and judiciary. But the proper role of the court is not limited to that, and particularly with ECTs, because ECTs are often hybrid bodies. Of course, they exercise judicial functions, but they may also exercise administrative functions, that is, functions of the executive arm of government, that's seen in merits review, but they also may have delegated lawmaking capacity, particularly in making rules of court. And so there can be seen to be some legislative function. Now, institutional competence is different. It's involved with the capacity of the institutions of governments to make certain decisions. So for a court, it involves looking at the particular functions, and one of the key processes is adjudication, and seeing what is the competence of the institution to exercise that function. And when we look at an ECT, which has many different functions, we will see that these concepts of constitutional and institutional competences operate differently depending upon the function. So, for example, it'll operate differently for judicial review than it will for merits review. Let's turn to a different skill set, and that's the expertises. And again, I'm going to group these into categories. First, the contributory expertise, and the second, the interactional expertise. So by contributory expertise, I'm referring to the sets of skills, knowledge, and expertises that are needed to contribute to the development of environmental law and the institutions that administer environmental law. And primarily, this is legal expertise. But interactional expertise refers to the need to interact with other disciplines, such as the sciences, social sciences, political sciences, economics, and see how they relate to the environmental problems and how those disciplines conceptualize the environmental problems. So interactional expertise assists an ECT in understanding environmental problems and how they should be resolved. So when we're coming to look at the institutional design of an ECT, there's a need to incorporate both contributory and interactional expertise. And that can be done by having two types of decision makers: judges, who have the legal or contributory expertise, and the technical experts who have the interactional expertise. But also there'll be an interaction between those two sets of decision makers. And that creates a new epistemic community. So Geeta Gill says, who's going to speak later, and she was referring to India's NGT, but this could be applicable to other ECTs. The multifaceted, multi-skilled body encourages a coherent and effective institutional mechanism to adjudicate complex laws and principles in a consistent manner, while simultaneously reshaping the approach to environmental problem solving rather than being limited to predetermined remedies.
Apologies, Justice Preston, we are running out of time.
Okay, I'll finish up. So I'll just give this last frame. So when we come back to use those building blocks of skills and expertise, there's another way we could look at whether ECTs are able to deliver environmental justice. And that's through these frames: function, doctrine, and process. So function is the functional role of the ECT in contributing to environmental law. Doctrine is how has the ECT developed environmental law, and particularly where it's environmental justice. And the process is the processes used to resolve the environmental disputes. So I won't elaborate on that because we're running out of time, but each of those three analytical frames can assist in getting to the point of understanding whether ECTs can deliver environmental justice. And bringing those three together, ECTs need to look at their functions and processes, have a feedback loop, adaptively manage those processes to better execute their functions. And in doing that, they will develop doctrine. And of course, we're interested in the development of doctrine in relation to environmental justice. Thank you.
Thank you so much, Justice Preston. There's a lot to unpack. I'm pretty sure in the article in our book later in 2023, we will have more detailed and deeper explanation in Justice Preston's chapter. For the second presentation, I would like to invite Matthew Baird. I don't think we need to have further introduction about him, but since he's preparing his PowerPoint to be shared, I will just read his short bio. Matthew Baird is the director of ARIEL and has over 32 years of experience in environmental and planning law in Australia. He's a member of Law Asia Community on Environmental Law and the IUCN WCIEL. Matthew was called to the NSW Australia Bar in 1991 and specialized in environmental and planning law. From 2016 to 2020, he was a visiting scholar to the Myanmar Environmental Governance Program at Vermont Law School. He is an honorary research fellow at the Myanmar Center for Responsible Business, and from 2020, a fellow of Environment Institute of Australia and New Zealand. He was appointed a teaching fellow at the College of Law Australia in 2021. So Matthew, the floor is yours for 15 minutes.
Thank you very much indeed. And can everyone see my screen?
Yes, very clear.
Thank you. And thank you, Linda, very much for the kind introduction. And it's a great pleasure to be here. And I should also acknowledge it's a great pleasure to follow Justice Preston. Not only was he my pupil master when I came to the bar, so I can blame many things on him, but of course, as a mentor and as a judge, he's identified the great challenge that we have for environmental courts, that we can't just set up environmental courts and tribunals. We have to ensure that those courts and tribunals or green benches or however we deal with environmental disputes are actually focusing on achieving environmental justice. And I think that's one of these sort of really crucial things, that we're not there to think about these as institutions, but we want to see them of how they are going to actually and effectively resolve our environmental disputes in a way that protects and preserves the environment. And that's, of course, always one of those foundational challenges, is whether an environmental court and tribunal is there to merely interpret the law or to ensure that the law is interpreted in accordance with environmental law principles and practices that require us now to take action to protect the environment and to be stronger for environmental protection and natural resource conservation than perhaps it is for development. And Justice Preston highlighted that that was certainly one of the challenges that many environmental courts and tribunals with broad jurisdiction will have, that they will have to enter into sort of policy discussions, which can be challenging for courts and tribunals. I wanted to say that the chapter that we're looking at and the issue that Rocky and I have focused on is in respect of rules of procedure in environmental courts and tribunals. And I was very privileged, of course, that most of my practicing life was in the Land and Environment Court, where one didn't have to discuss or explain to a judge what the environment was or what sustainable development was, or various environmental law principles. The challenges that one had as an advocate was to explain how those principles applied and how the law should be interpreted in accordance with those principles in specific cases. And that was certainly a great benefit for me. The work that we've done over the last 10 years, 12 years in the Asia Pacific region makes it clear that the challenges that are faced within the region are very different from those challenges faced in a country such as Australia. And that means very much that we have to focus and refocus our attention on what is an effective way of achieving those environmental justice outcomes as identified by Justice Preston. We can see that environmental courts and tribunals do have certain values, especially if they can streamline access to environmental justice. It can act as an accountability function, and it can enforce commitment to environmental agreements, not only at an international level or through constitutional provisions, but also enforcing that commitment to the national law and compliance with the national law, which is a key identification and a key component of the work of all tribunals and courts. We do think at this point of time that ECTs are essential to enforcing these new rights, recognised rights, in particular the right to a clean, healthy and sustainable environment, a right not only recognised by the United Nations General Assembly recently, but a right clearly identified in the ASEAN Human Rights Declaration. And it shows that these rights are also recognised in many constitutions within the Asia-Pacific region. I wanted to sort of quickly move on in looking at the framework rules and practices for environmental courts and tribunals, and picking up, of course, those 8 points that Justice Preston identified, and identifying that these are really certain fundamental elements that are necessary in the design of environmental court and tribunal to ensure that it can be effective, or at least has the opportunity to being effective. And the world is littered with experiences of environmental courts and tribunals that have been ineffective and have been left to languish or perhaps been abolished. And that's something that we always have to take into account. In terms of the frameworks that we've been looking at, and this also formed the basis of some of the work that Rocky and I did in advising the Ethiopian government when they were looking at setting up an environmental tribunal before the previous election and the civil war that broke out. But they were looking at setting up an environmental tribunal, and we provided some assistance, and in doing that, we looked at a number of different models. But we also saw that it was very important that the court needed to be independent, either practically, functionally or operationally. There needed to be certainly the involvement or the opportunity for non-state actors, for civil society to be able to participate. We looked at relaxed rules of standing. In recognition of the New South Wales Environmental Planning and Assessment Act, that Section 123 provided that any person could approach the court to remedy or rectify a breach or apprehended or threatened breach of an environmental planning law, a very broad standing provision that had not and has not to date resulted in the loss of any effectiveness or for environmental law. But it had relaxed rules of standing that any person or NGO could bring an action before the court. The importance of provisional and interim measures within the courts to ensure that the environment and this could be protected during the course of conduct of the litigation. Also, the idea of appropriate methods of dispute resolutions. Issues should not just be resolved in terms of litigation, but mediation, conciliation, arbitration, or other forms of neutral evaluation should also be looked at as a dispute resolution mechanism. We also saw that there needed to be, within the rules of procedures, provisions against strategic lawsuits, against public participation. I remember just recently, the Supreme Court of South Africa identified in a SLAP suit and found that it was an abusive process, that one defendant had brought an action against two plaintiffs and one lawyer to try and prevent them from bringing cases against a particular mining company. And that was held to be an abusive process, something that I think needs to be further identified, that those actions that are trying to reduce the access to environmental justice should be dealt with at a professional level as well as by the courts. We also looked at principles to be applied, core principles, environmental law principles that can be addressed by the court and indeed provided their decision-making with a certain matrix, a certain basis and principles to be applied. And the idea, the importance of special rules of procedure in environmental cases. In terms of looking at some of the best practices within the region, we can see that within the Asia-Pacific region, there are some good practices that are there with the existence of either environmental courts and tribunals or on green benches. There are certain things that allow the courts, and I mentioned, for example, Pakistan and the Philippines, the continuing mandamus rule that allows for extended supervision. In India, the suo motu powers of the Green Tribunal. In New Zealand, the recognition of a legal personhood conferred on land and, in certain cases, water. In Indonesia, green judges, for example, receive specialist training on environmental cases before they can be certified as judges to hear environmental cases. And in the Philippines, the Supreme Court has the rules of procedure in environmental cases, which provides for temporary environmental protection orders and also the writ of kalakasan. Again, some of these issues and some of these good practices need also to go back and be re-examined in the light of Justice Preston's comments of whether these are producing effective environmental courts and tribunals. So look, I just wanted to close in some respects by giving an example that of some of the work that we did on this environmental tribunal in Ethiopia. It hasn't been proclaimed and the procedures are still waiting until the situation there quietens down. But what happened within this environmental tribunal in terms of drafting the proclamation and also drafting the rules of procedure was it looked at key elements from the Land and Environment Court in New South Wales, India's Green Tribunal, the Supreme Court of the Philippines, the Kenya Environment Court and the Ontario Environmental Tribunal, all of whom provided certain elements for their decision-making and for the focus of decision-making that were considered to be a good practice or best practice. The tribunal, in its creation, looked at having judicial and expert members. It looked at having as an overriding objective of the tribunal the just, expeditious, proportionate and accessible resolution of disputes. It brought forward the idea that any person would have standing to bring a case. It also had some guiding principles in terms of the human right to a safe and healthy environment, which was recognised in the federal constitution of Ethiopia. But it also identified that the court would have regard to certain principles in making its determinations in terms of polluter pays, intergenerational and intergenerational equity, prevention, precautionary principles, sustainable development, ecological integrity, and the promotion of access to environmental justice. So those principles were identified as guiding principles within the proclamation that set up the tribunal. It also had provision for expert witnesses and for alternative dispute resolution as being a necessary part of the court process. Of course, those ADR processes were enlivened when a claim was made to the tribunal. The tribunal also ensured that within its overriding objective, the tribunal members were able to, or there was a registrar who was appointed to assist people in actually commencing their procedure or commencing their applications. Within the rules of procedure, which were drafted after the proclamation and are there sitting there as a package, it set out a case management approach that is a modern way of dealing with most litigation or most environmental disputes, that it would have a case management approach. So the court could impose a form and a process on the dispute to ensure that it was effectively resolved, but in accordance with those key principles. There were also measures for interim relief and environmental protection orders brought forward from that Philippines Supreme Court rules of procedure that ensured that the environment would be protected as an integral part of the process of the case management, so that the plaintiff or the applicant didn't have to actually apply for environmental protection orders. This was deemed to be something that would occur. As I said, the applicant could approach the tribunal for assistance in commencing claims. It also looked at online or in person, using regional courts potentially as registered where the filings could be made. One of the challenges in Ethiopia was that even the internet was not very effective, but certainly people could not come to the national capital of Addis Ababa. That would minimise their chances for access to justice. It had provision for neutral evaluation and mediation, and the expert witnesses were subject to procedures to reduce areas of dispute and focus on key matters in dispute. And ultimately, the tribunal had the guiding role in the management of cases to reduce cost and promote access to environmental justice. One of the things we can see that there is also a consequence of environmental courts and tribunals and green benches. It does require a high level of public participation and engagement. We hope that it promotes more inclusive participation, in particular from minorities, women, and vulnerable people. But we also know that the courts need to be gender responsive, which is an ongoing challenge and work done by Asian Development Bank, in particular on gender issues in countries such as Pakistan, Afghanistan before the fall, and in Fiji and the Pacific are very important to bring that. But the important thing that we hope that environmental courts and tribunals can do is identify those links to poverty, environmental degradation, and environmental justice, and provide greater state accountability and greater business accountability through the use of proceedings. And hopefully, and above all, we hope, and we have this aspiration, that environmental courts and tribunals can promote sustainable, inclusive economic development. Thank you very much for the opportunity to present today.
Thank you so much, Matthew, for your presentation. I think it's very interesting how you compare it, our region with the one that is flourishing in Ethiopia. I think that's a fresh perspective, I suppose. We haven't really had that kind of comparison previously. Our next presenter is our author for the chapter called Training and Networking for Environmental Courts and Tribunals in Asia Pacific. I would like to kindly call Briony Eales. Briony Eales is an environmental and social and governance lawyer. She is the team leader for ADB, Asian Development Bank's Environment and Climate Change Law Judicial Capacity Building Program. This program supports judiciaries in Asia and the Pacific to strengthen their knowledge and procedures for environmental and climate change law adjudication. Briony was the lead editor and the lead author of Climate Change Coming Soon to a Court Near You, ADB's 4-part report series. The report explored climate change law, policy, and litigation in Asia and the Pacific and present a fresh narrative about the nature of regional climate litigation. Briony also contributed to ADB's 2021 report, Gender Inclusive Legislative Framework and Laws to Strengthen Women's Resilience to Climate Change and Disaster. Briony has advised public and private sector clients for over 20 years in Australia and across Asia. Her work has included updates to national climate law, climate change strategy, and laws on environmental crime. She has also advised corporate entities on resettlement, engaging with Indigenous communities, and risk. Briony, the floor is yours for 15 minutes.
Thank you so much. I think someone is going to drive my slides for me. Thanks, Joelle. Great. So thank you so much, Linda. It's, again, such a delight to be included in this panel. Chief Justice Brian Preston and Matthew Baird are really inspiring, and I always learn so much from them. And thank you to APCEL for taking leadership on this project. So let me start by considering the role of judges and why they are so crucial to the transformational change needed if our global community is to have a chance at meeting its collective goals on the triple planetary crisis, which are climate change, pollution, and biodiversity loss. And so in that regard, I also wanted to stress that the central premise of the chapter that we will be writing will be ensuring that the work that ADB does in working on judicial education or judicial training and networking supports judiciaries to deliver justice, and that is implementable and makes a difference. So I agree with what Justice Preston said about ensuring that what we do makes a difference. So making measurable progress on the world's current climate and environmental crises requires unprecedented levels of change. And as I mentioned before, the types of change are unprecedented. And so we need 21st century solutions, including legal solutions for our 21st century challenges. And that also means that it's critical that the law rises to the challenge and supports and enables a just transition. So at ADB, we believe that to bring about a whole of economy shifts for this just transition, we need all arms of government to function at peak performance levels. And all of them need to be informed, involved, well-trained, and efficient. We cannot overlook the ECTs and judges as essential partners in these whole of economy shifts. They are the arm of government responsible for upholding, interpreting, and validating national laws and protecting the rights of citizens affected by environmental crises. So next slide, please. Both the Sustainable Development Goals and ADB Strategy 2030 recognize that the rule of law is essential for promoting equal access to justice, sustaining development momentum, and ensuring that the benefits of growth are equitably and widely shared, which is partly why we do this work. Next slide, please. For the past decade, much of the development work that has been done by multilateral development banks has focused on supporting governments at the sectoral level to achieve their national goals and targets for sustainable development. But ADB is shifting its focus to the whole of economy integrated and multi-stakeholder approaches. And so what that means is we're starting to look upstream at what is effective for implementing environmental, biodiversity, and climate goals in our developing member countries. And judiciaries and ECTs sit at that upstream level because they have that holistic perspective. A crucial part of keeping judges involved and informed is providing them then with opportunities to participate in training and judicial exchanges on global environmental, climate change, and biodiversity law. You may be aware that ADB has worked now for over a decade with judiciaries and ECTs in Asia and the Pacific. And we did that because we noticed that while a lot of money was going to the executive arm, not much was being focused on judiciaries, despite them being responsible for critical decisions that have tremendous implications for sustainable development. The program that we run focuses on how do we achieve more effective implementation and enforcement of laws, along with effective and efficient adjudication of environmental and climate change matters, gender-based violence, and also commercial cases. And over time, we have developed partnerships with over 30 Supreme Courts in Asia and the Pacific, as well as links to courts and judicial associations around the globe. So that would include the Global Judicial Institute for the Environment and the European Union Forum of Judges on the Environment. Sorry. Next slide. Next slide, please. To date, ADB's judicial program has really focused on two core areas which are interlinked. And these focuses are on the technical support for training and resources combined with judicial networks. So for over a decade, we have done things like support judiciaries and ECTs to establish green and environmental benches or courts, assisted judiciaries in creating certification programs on environmental law. We've provided expert assistance in drafting environmental court procedures. And a key part of what we have done is convening regional conferences to promote regional judicial dialogue and knowledge sharing, which has been a really effective vehicle for cross-fertilization of ideas between judges in different countries. We also now run online workshops on emerging areas of law, and we supported the creation of the Asian Judges Network on the Environment, which is usually the banner under which we have our regional dialogues. Next slide, please. Next, thanks. Knowledge resources are, sorry, go back to the previous slide. Knowledge resources are a critical component of the work that we do. So this work that we did in 2020, which is climate change coming soon to a court near you, was really one of the first and most extensive reviews or surveys of what climate litigation, law, policy, and legal frameworks look like in Asia and the Pacific. Because climate change cases and environmental cases have a different personality, and it's important to start talking about how those cases contribute to the global dialogue on jurisprudence. Next slide. It's really hard to measure the outcomes and the impact of judicial education. And that comes back to the point of how do we know that we're being effective? So if we could move to the next slide, please, Joel. Thank you. And that's coming back to this point of tracking impacts. But so far, what we are starting to see are landmark decisions written by judges who have actually participated in ADB programs. So, for example, the Lagari decision, Pakistan's most foremost climate change case from 2018, which led to the implementation of Pakistan's climate change policy framework, and the passage of Pakistan's climate law, was written by a judge who had been coming to ADB programs. Likewise, the decision of Shrestha versus the Prime Minister and the Office of Council of Ministers and others from Nepal, which is a groundbreaking case where the Supreme Court of Nepal ordered the national government to pass a climate change law, was again written by a judge participating in ADB's programs. In the matter of Marua and China Harbour Engineering from Papua New Guinea, this is an example of the Supreme Court of Papua New Guinea confirming that plaintiffs had standing to pursue their case based on constitutional rights. But the court also exercised its power of suo motu to join other defendants to the proceedings. The judge who wrote that case became aware of how courts in the NGT in India had used its suo motu power and then applied it in the PNG context after realizing that that right was available in Papua New Guinea. And furthermore, in a recent case from Lahore, the High Court of Lahore, Farooq versus the government of Punjab, the court referenced ADB's climate law report series, describing it as a leading resource. So, you know, obviously, while that gives us heart, my key takeaway from this slide is that we are starting to see the fruits of our labor, and that is better quality environmental jurisprudence flowing in response to investments that are made in environmental courts and tribunals. And this project, this chapter, will hopefully allow us to examine more closely how we might measure that impact and use that moving forward. We are also starting to see the work that we do being incorporated at the international level. So in May 2022, ADB partnered with the Global Judicial Institute on Environment and the International Association of Judges to host 2 events at Stockholm Plus 50. This was this is the first time judges had participated in a UN environmental summit as stakeholders. Inga Anderson, Secretary General of UNEP, attended the symposium that we held, and in her closing address, she acknowledged the participation of judges, which is critical because the other point to remember is that at the end of Stockholm Plus 50, key recommendations for accelerating action toward a healthy planet include things like strengthening the environmental rule of law to enable countries to deliver on their national and global commitments. So again, ECTs sit at the heart of this work. Next slide, please. So, but despite the work that's being done, it's clearly not done. And we need to consider where to next. You know, despite all of the, we're still facing environmental biodiversity decline at an increasing rate. So things that ADB are looking at is how we might continue to work with our development partners to rise to the challenge and support ECTs in Asia and the Pacific to become more effective. And also, COVID-19 changed how we run our program and forced us more into the virtual world, which has some benefits, because whilst on face-to-face training is always very effective, we need change at scale, and we need to be able to reach many people, which virtual environments enable us to do. Also, if we're going to think about judicial education, something that ADB needs to consider is, what do we need to skill judges for? What role do they need to play in environmental, climate, and earth justice in the coming decade? We are still working with judges on these issues, and we will continue to take feedback and be grateful to the judges who give us ideas for moving on. So Justice Preston has always been very gracious with his time and efforts. But we do need new perspectives, and justice will only be fair if it considers diverse perspectives and rights. As Matthew said, we need to ensure that justice is granted to women, children, elders, Indigenous peoples, people with disabilities, future generations, and nature. And we need to balance that with traditional structures. And these considerations give us an idea about the qualities that we need in judges. Moving forward, our current program looks like what I've outlined on this slide. So we will continue to work with judiciaries, and what we're trying to do is embed judicial education programs on climate and environmental law in judicial training institutes and develop a curriculum that we can use in various judiciaries. We will also work with regional bodies to support them with regional education programs. And we remain interested in continuing to do regional judicial networking events, which have previously been the mainstay of our program. A new innovation that we're working on is a series of judicial masterclass series where we do deep dive interviews with senior judges in Asia and the Pacific. These interviews will create media resources which ask the questions that junior judges might want to know about procedural issues or substantive justice. And it allows us to use these resources either in a virtual world or to workshop them face-to-face. And it also takes the pressure off these senior judges coming back all the time to our training programs. We are looking at working with female judges. A number of female environmental judges are interested in creating a network of women judges in Asia. And one last initiative that we're really excited about is looking at, in the Pacific, the potential to explore a green dispute resolution mechanism to contribute to environmental governance in the Pacific. So I guess to sum up and to talk about where we go, it's worthwhile remembering that judges are human and they're not immune to human conditions of feelings and compassion, inconsistency, uncertainty, and bias. So the next slide, please. In the recent work by Daniel Kahneman, who is a Nobel Prize winner in economic sciences, he recently co-authored a book on noise and bias in decision-making, which included looking at courts. And he talked about how some judgments are biased, so they're systematically off target. Others are noisy. So that means people who are expected to agree and end up at very different points don't. Next slide, please. What we can do, he suggests, is that highly skilled people are less noisy and they show less bias. And that is why ADB does the work that it does to support judges, and we will continue to do so. So summing up, we are looking at how we make our program structured in a way that continues to support judges to meet the challenges that are coming their way. So thank you very much for your time.
Thank you, Briony, for the fresh upstream perspective towards the ECT and specifically the need for training judges, our pinpoint person in terms of when we're talking about how to solve environmental cases in ECTs. So ladies and gentlemen, we have until 3:30, so around 12 minutes for question and answer. We have the first question from Mr. Pankaj Kumar. He's from Jawaharlal Nehru University. His question is, He says that most ECTs are, or there is reluctant approach towards engaging with climate law or justice or policy of their respective countries. Why do you think this is for ECTs? Is climate change too contentious issues to be tackled by these ECTs? What do you think, Justice Preston?
In short, answer is no, it's not too contentious. And indeed, if ECTs don't deal with the issue of climate change, one of the triple planetary crises, then what are they going to do? That really is an essential aspect. And of course, climate change, picking up on my point, raises all three issues of environmental justice, but particularly distributive justice. So I think that courts, all courts, but particularly ECTs, do need to deal with climate change issues. If we avoid doing that, then I think we're avoiding doing our duty. It's the way in which we go about it. The courts have to keep within their proper province. They have to apply legal method and judicial method in decision making. But there are these leeways of choice in judicial decision making, and we need to be conscious of the opportunities for resolving the climate crisis. That doesn't mean to say we have our own agenda, that we go off and do things that courts shouldn't do. I'm saying that we do what the courts are meant to do, and that should involve giving climate justice. So no, I think it's essentially what we should be doing.
Thank you so much, Judge Preston. Next question is from Francine Hug to, I think Matthew and Briony can tackle this question. So she's asking, well, Francine Hug is from University of Hawaii. So she's asking about how could regional ECT mechanisms in Pacific Islands nations can be improved, especially with regards to environmental and social impacts on indigenous communities in land and seabed, in deep seabed mining, exploration and exploitation projects in several Pacific Island nations. What do you think, Matthew or Briony first?
I'm happy to defer to Briony.
Okay.
I was about to say, why don't you start, Matthew, and then
Go ahead, Matthew, please.
So I think this is very good. I mean, Briony, I will leave it to you to talk about the Pacific Environmental Tribunal initiative, if I may. But I think the really interesting thing is that both in terms of regional mechanisms, which highlights, I think, one of the challenges that all environmental courts and tribunals face. One is jurisdiction, the other is resources. The Pacific Islands themselves have traditions of allowing foreign judges or judges from foreign jurisdictions to assist in their court of appeal in their final courts, recognizing the need to have a broader, jurisdictional knowledge to assist in the determination of environmental and other disputes. But I also I note that in the Caribbean, there are, and in Africa, there are actual regional tribunals that deal with a range of matters. In the Caribbean, it's a range of matters that the states have come together to recognize that there are sort of multi-jurisdictional issues. I think in the Pacific, there's a great opportunity also to acknowledge Indigenous people, who are obviously a majority in many of the countries, and to then apply a number of international principles, in particular of free, prior, informed consent, but also in terms of consultation, public participation. There was the challenge of setting up a regional tribunal to deal with environmental matters is still there, but it's something that is being looked at. It's also interesting to see that Fiji, with its new climate change legislation, how the courts can also be skilled and developed at a national level so as to implement those things. But I think that in terms of those mechanisms to be improved, one of the things is to raise the idea of a regional tribunal to deal with environmental matters, and that's something that at least Briony can talk about an exciting new project that has just was launched actually at the IUCN Academy of Environmental Law with judges in the Pacific and Australia and experts from the region. So I might hand it to Briony at that point.
Thanks, Matthew. So yeah, I mean, I absolutely agree with what Matthew has said about the potential benefits. I think it comes back to what are the challenges that we're looking for, what are the challenges that are likely to come up in the next 10, 20, 30 years? And in the Pacific, it's things like rising sea levels, resource use, oceans, and a lot of those tend to be transboundary or might include multinational corporations. And so there would be benefits to a regional mechanism that might have the capacity to deal with these bigger issues, and it might have the capacity to look at these cross-border issues, but also when you're dealing with multinational corporations, a lot of the time you want to ensure there is voluntary dispute resolution mechanisms in place that facilitate access to community members. And something like this body that we're going to explore the different options might enable that. And it has to be, obviously, we're aware of the need for treaties and we're aware of the need for judiciaries to be on board. But some of the constraints that exist in the Pacific right now are, as Matthew said, resources, and that can impact the quality of dispute resolution mechanisms and adjudication. So this centralized body might enable those resources to be available, that specialized expertise to be available. So there are all the different things that we're looking at, and we are really excited. This is something that the Pacific has been calling for over 20 years. And we're aware that it's something that could take time, but really what we're interested in doing is a process that might be scaled. So it might start with voluntary dispute resolution mechanism, and that over time becomes a full-blown tribunal or green court for the region. But just critically, that it enables people to access justice in a way that they're not currently able to access justice. And that's why we think it's important for governance. And that's what we're looking at. Thank you.
Thank you, Briony. Justice Preston, I remember you also have an idea of mobile, not only regional, but also mobile ECT for the Pacific Islands nations. If you like to talk, just making a full circle of the answers from Matthew and Briony.
Yeah, well, in order to work, it still has to be accepted by each of the countries there. But yes, the idea would be if the way it would operate a pan-Pacific environmental court tribunal, each of the countries has to give that body jurisdiction to deal with disputes. But then you can have the judges and tribunal members go from country to country. And so, and not only to country, but then importantly, I think in a place like Papua New Guinea, you go into the particular regions, places where if people find it difficult to get to, Port Moresby or the main capital. So it would be a case of the ECT going to the people and the dispute. And that has the advantage that each country doesn't have to replicate an ECT, because it's a problem to get not only the financial resources to do it, but access to the quality decision makers. You know, I said a successful ECT is that you have to have, you know, knowledgeable and expert decision makers who are going to be part of that. A lot of these countries just can't access that. They may not have homegrown experts, and you know, people from overseas are not prepared to do it. But if you had one central body who can then go to the people, then yes, you've got much better chance of attracting people. And so it's a way of ensuring that you distribute the, you know, financial, human resources and material resources throughout the region.
Thank you, Justice Preston. There's a message here from Gita also. Prof. Gita is saying that an example from NGT is a circuit court that revolves around the area of the country. So, okay, so for session one, we have to end it here. We ran out of time. I would like to thank Justice Preston, Matthew Baird, and Briony Eales for the tremendously rich discussion in our first session. And thank you for all the participants for the questions also. We will have a 10-minute break, and then after that, we'll continue with session 2. And there will be an option on the bottom of your screen where would you like your panel to be. Just click on the option of the rooms of the panel, and then you will be there. So currently it's 3:30 p.m. Singapore time. We'll have 10 minutes break. We'll see you again at 3:40 Singapore time. Thank you very much.
Panel of exceptional speakers that we're keen to get through. So our first panelist is, sorry, I'll just pull my notes up. Not that Linda needs any introduction, but anyway, Associate Professor Linda Yanti Sulistiawati, and I hope that I pronounced your surname correctly, Linda. But
excellent,
Linda,
excellent.
Linda is a senior research fellow at APCEL and also an associate professor of law in the Universitas Gajah Mada. So her research focuses on international environmental issues like climate change, REDD+, land issues, and customary issues. She was a member of the delegation leading Indonesia's negotiations of the Paris Agreement on climate change in 2015. And from 2018 to 2022, Linda was actually a lead author of the IPCC's 6th assessment report, which is fascinating. And in 2021, Linda was the lead author for UNEP's Environmental Courts and Tribunals guideline for policymakers in 2021. Linda is going to be talking to us about Asia-Pacific regional perspectives on ECTs, the way forward. Linda, the floor is yours. I really look forward to your discussion.
Thank you so much, Briony. I hope everybody can see my screen. I'm starting SlideShare now. Is this feasible?
Yes, I can see them. Yes.
Okay. Okay. So thank you again, ladies and gentlemen. My chapter is on Asia-Pacific regional perspective on ECTs, the way forward specifically. I'm just very glad we went through the first session, and I'm glad that whatever I wrote in this PowerPoint is not in contradiction to what the prestigious panelists in the session 1 was already discussing. Whew, okay, so which means that we are in the right track. So my name is Linda Yanti Sulistiawati. I'm a senior research fellow at the Asia Pacific Center for Environmental Law at National University of Singapore. I also am teaching at the Gajah Mada University, Yogyakarta, Indonesia Law School. Okay, so as with the previous panelists and also authors, my section, my chapter is also building upon the newly launched 2021 Guide for Policymakers, Environmental Courts and Tribunal. So the UNEP's guide indicated that the world's environmental courts and tribunals are in steady increase. So there were 1,500 plus ECTs in 2016, and the numbers of ECTs grow in 2021 to 2,116 in 67 countries. So which means there are like high conviction rates, higher environmental cases in all regions in the world, and specifically in Asia Pacific. So like the other previous panelists, this report also acknowledged why not all countries have ECTs, and it gives social, political, economic, and jurisdiction challenges as a response. And if you see it on your slide, here is the map of the ECTs in the world today, the global distribution of ECTs. You see the group, the blue map in the maps are the countries that has ECTs. There are some countries with potential ECT but not authorized, and there are countries with without ECTs because they discontinued the ECT, and countries with without an ECT and with only pending ECTs. So some countries, which you will know later on if you follow like all these authors' presentations. Specifically, I would mention China, for example, have massive development in terms of environmental courts and tribunal. Since 2016, there are at least, so there's more than 1,500 ECTs established from 2016 until 2021. But there are also other countries in our region, like India and Pakistan and Indonesia and Thailand. So India and Pakistan decided to just keep their ECT numbers intact, but they're building upon their green benches. Indonesia and Thailand, for example, they're training their judges with more technical and also environmental law aspects to handle environmental cases in the general courts. So good practices characteristics are also highlighted. We see the independence, we see flexibility, we also see non-law decision maker as part of the judging committee. We have selection and training of adjudicators. We have alternative dispute resolution, comprehensive jurisdiction, the flexible rule of standing, remedy, and evaluation procedures, and adequate resources. I will also like touch upon very lightly on why China is such a good practice example for ECTs. Of course, Pei Xuan and also Yu Hong will later dig deeper in the book on why China is such a good discussion starter when we are talking about the modern ECTs. But among others, in China, there are like the promotion of integrated ecosystem approach to environmental governance. They have transparency for environmental adjudication. They have disclosure and public participation, such as open trial system, where live trial are broadcasted on China open trial websites, such as WeChat and Weibo. There are a court to establish 7-member collegial panels, which are 3 judges and 4 public representatives for cases involving major social impacts and environmental public international law cases. And also they invite public representatives and students in cases that have significant impacts with their jurisdiction to promote transparency and openness of environmental adjudication. The second one, the good practice that I will also like slightly mention in my article would be the National Green Tribunal of India. Of course, the postcard ECT of Asia, because of their accessible broad standing rule that individual can directly go to court without lawyers, that person may bring their claims in the public interest, even if they don't have any direct personal connection to the matter. And a person may bring a claim on behalf of a group of people, such as all those living in the village or all fisher folk reliant to certain fisheries, for example. And of course, that Matthew already mentioned in the first session, the suo motu motion by the court to directly bring the motion itself in a case. The highlight of NGT is, I think, they managed to provide good environmental jurisprudence in India, which are impact assessments and restitution, which became important parts of the Indian law. Green benches in Pakistan, Indonesia, and Thailand is, of course, would also be part of an alternative. If you don't have an ECTs, what can you do in your country, right? What kind of training that they do specifically, like in Pakistan, because they only have limited number of environmental tribunals, they decided to train their judges and designate green bench judges presiding over environmental related cases. In Indonesia, they train their judges, their general court judges, with environmental issues and give them certification, environmental law certification, because it's hard for the country due to political and capacity constraints to make, new institutions such as, independent institutions such as ECTs within the current civil and criminal codes that's already established in the country. Similarly, Thailand court and government organized generals and specific training courses for its general court judges in environmental matters, and regularly provide scholarship to judges to study environmental law abroad. I think, like in most of these countries, I'm pretty sure Briony and her team are already involved in this particular judges training. And then we also have what we call comprehensive jurisdiction. I know Judge Preston earlier already highlighted, what they are and, why they're important. Specifically, geographic jurisdiction was even a question in session 1. How to make ECT more more able to increase their performance in adjudicating environmental cases, not only building regional scheme, but also maybe mobile courthouses. We have this already in the Philippines, in our region, but maybe replicating it in the Pacific Island countries would also be possibility. And also subject matter jurisdiction, good practice to give the ECT the ability to adjudicate disputes, frequently involve more than just one aspect, because there are civil, criminal, and administrative issues together. So good practice for India and the Philippines is using the use of express statutory authority to apply constitutional law and international environmental law principle in the adjudication process. And then for level jurisdiction in Pakistan and China, they have created environmental courts or green benches at all 3 levels, the trial, appeal, and Supreme Court. For example, if the country can only have 1 level that is approved to have ECTs. So initially, good practice is to have the ECT at the first instance level to develop a solid record for appeal. So from these deliberations, the ECTs in Asia Pacific plays many roles in their jurisdiction, but I think the most prominent roles are firstly to provide environmental cases resolutions, which is their function, right? And then secondly, to provide environmental jurisprudence that we saw in countries, like with more prominent ECTs, but also in other countries, they will and produce all of this. And then this third one is a forum of expression and public discourse. This was also mentioned by Justice Preston. So it's not just a court to discuss legal problem, but also to discuss the current situation that is happening in terms of environmental issues. And then the fourth one is the ECTs can provide equality, because sometimes when we see an environmental case is individual versus government, individual versus companies, or company versus government, or state versus company. So all of this actors are not in the same bargaining position, but once you're in the ECTs, they're all in the same level of playing field. They're all litigants in the eyes of the ECTs. And my fifth one is ECT as environmental safeguard last resort option. So all litigants know that they, well, not just litigants, but I think public at large know when they have ECT in their country, they would understand that there is a place that they can go to as last resort to resolve their problem, right? Their environmental problem. So I think those are the roles that I will highlight in my article. And the way forward for ECTs to be successful, I'm pretty sure Judge Preston already mentioned most of this in his article, and also I think Prof. Terry Warnock also highlighted how to make an ECT successful in his current book. The ECTs are depending upon, the first one is government and stakeholder support. The second one is sufficient IT infrastructure. The third one is guarantee or evidence of environmental legislation enforcement. And the fourth one is ECT being sensitive to the global environmental landscape. So this is where I conclude my chapter. When I will sort of explain that ECT's existence, jurisdiction, power, budget, accountability mechanism, etc., may be defined by legislation, rules of their parent branch of government, or its own rules. But all of this are depending upon political will of the government and also the stakeholder support. Public and academia support may not be in terms of monetary form, but their participation and pressures can move governmental support toward the ECT. As long as the ECT still our priority issue, maintaining the momentum to have full support from the government and the non-state actors are crucial for the ECT itself. And second one, I think this has been discussed by Judge Preston and also Matthew about IT and infrastructure and how it is instrumental when we are talking about, COVID and also post-COVID. We've seen this in India, NGT, for example, but, very hard to replicate it in developing countries because of, many challenges. And this one is also important. I think if the environmental legislation is not enforced, it will be hard for ECT to sort of, say that, hey, we can resolve your cases. But this is particularly a problem in several parts of the world, including the Caribbean, for example. Enforcement problem due to the lack of financial and human resources have been reported. I'm pretty sure a similar situation is also faced in our neck of the wood, in our part of the world. And then this is my last point is that being sensitive to the global environmental landscape, there are so many things that would be discussed in the cases that will be faced by the ECTs in our region. More mitigation adaptation, NDCs from the Paris Agreement, forest fires, marine plastic pollution issues, and then Glasgow issues or the Conference of Parties issues, global stocktake, palm oil, coal industry, and then what Briony mentioned earlier, the gender issues, and also youth movements and non-state actor movements. I'm going to wrap up my presentation here, but I will be glad to entertain questions from you. Back to you, Briony.
Thanks so much, Linda. I think it's such a great point to highlight that it is a two-way street and that there needs to be both support from governments and non-state actors and stakeholders who use any ECTs, but also that the ECTs maintain the trust of the communities that they work with by ensuring access to justice and that they enforce environmental laws and legislation. So thank you. That was a wonderful summary. So our next speaker is Professor Noriko Okubo, who specializes in administrative and environmental law and has done so since 2010. She has been the principal investigator of the International Comparative Study of Principle 10 of the Rio Declaration and Procedural Environmental Rights, including environmental public interest litigation, so the Green Access Project. Professor Okubo is currently working on 2 international comparative studies on the rights of nature and community rights in Southeast Asia. She holds a Master's of Law as well as a Doctor of Law from Hitotsubashi University. And after working as an associate professor at Guma University and a professor at Konan University, she has been a professor at Osaka University since 2015. She's currently working as executive director of the Environmental Law and Policy Association and is a member of the Science Council of Japan, the Central Environment Council, and the Council for Transport Policy, among others. Professor Okubo will be looking at a legal analysis of Japan's National Environmental Dispute Coordination Commission. So, Professor, the floor is yours.
Thank you for kind introduction. Do you hear me and see the slide? Okay.
Yes.
Thank you so much for your kind introduction, and thank you also for inviting me to this conference. I would like to express my special thanks to APCEL. Today, I will tell you about the Japanese ECT, which is quite unique and an old one among all ECTs. In Japan, there is no specialized court because the Constitution prohibits the establishment of any specialized court. However, since 1970s, the ordinary courts have developed environmental case law. Especially in the civil cases, there have been remarkable judgments concerning human health, such as Minamata disease cases and air-based cases. It includes cases that have admitted state liability due to omission of regulatory power and injunction on road pollution. As a result, original theories regarding causation, negligence, etc. have been developed. It is an important characteristic of Japanese environmental litigation. However, today, I don't talk about environmental litigation. I will talk about administrative ADR system in Japan. Because despite of many developments on environmental litigation, there are still various challenges for litigation, such as high cost, delayed procedures, and insufficient and/or rigid remedies. As environmental public interest litigation has not been introduced in Japan, especially environmental cases in nature protection and/or administrative matters have often been dismissed due to lack of legal standing. In order to resolve such issues, in 1970, 50 years ago, specialized administrative organizations for environmental alternative dispute resolution, EADR, was established based on the Act on the Settlement of Environmental Pollution Disputes. This slide shows the overall picture of the comprehensive system for resolving environmental dispute through litigation and ADR. Administrative ADR bodies consist of Environmental Dispute Coordination Committee, hereafter EDCC at the national level, and the prefecture pollution boards at the local level. Actually, I'm a member of Regional Board of Osaka. However, today I will focus on the EDCC at the national level. Same as ADR by courts, administrative ADR has common merits such as flexible proceedings and lower costs than litigation. In addition, the administrative ADR has remarkable advantages. First, it is possible to appoint technical experts as technical members to investigate professional matters. Second, the administrative ADR bodies can initiate a fact-finding process sua sponte. In addition, the EDCC can entrust technical investigations to research organizations at its own expense. This helps alleviate the financial burden to the parties and facilitates difficult fact-finding processes. Third, there is a way to reflect the experience and knowledge of ADR bodies in environmental policy. Namely, the EDCC may present its opinions on the implementation of environmental pollution control to the relevant administrative organs. The EDCC is a panel formed by 7 full-time and part-time members, including the chairperson. To ensure the fairness of dispute settlement, the EDCC is organized as a quasi-judicial and independent body. As I told you, EDCC is not a judicial body, but administrative body. However, it is independent. This is key. Its features are as follows. First, the chairperson and the commission members are appointed by the Prime Minister with the consent of the Diet. Diet means Congress. The EDCC members exercise their authority independently, and their status is guaranteed. In addition, depending on the case, the EDCC may appoint a maximum of 30 expert members. Second, the EDCC has a quasi-legislative authority to establish its own rules concerning affairs under its jurisdiction. Third, the EDCC has its own secretariat. This is very important, and some of its officials must have legal qualifications. There are examiners in the secretariat to support the EDCC members. In practice, persons with judicial experience and director-class persons from the relevant ministries are usually appointed as examiners. Examiners play also a very important role to resolve the disputes. This leads to increased expertise of the secretariat and strengthen cooperation with the relevant administrative organizations. This is advantage of the EDCC as administrative body. Fourth, the EDCC may hold public hearing to obtain public opinion. The EDCC provides mediation, conciliation, arbitration, and adjudication services. The EDCC may commence mediation or conciliation procedure sua sponte. It is a kind of suo motu system. If an environmental pollution dispute has arisen that causes considerable damage to a wide area and the parties' negotiations are not progressing smoothly, the EDCC may conduct mediation after researching the actual situation and hearing opinions from the parties. Adjudication consists of two types, namely adjudication of liability for damages and adjudication of the cause of damage. Adjudication of liability for damage is a procedure to determine the existence or non-existence of liability for damages. Adjudication of the cause of damage is a procedure to determine the causal relationship between offending actions and the damage. Between 1970 and 1991, the total number of registered cases of the EDCC was 1,101, and the total number of finalized cases was 1,053. Big cases against governmental organizations that are related to infrastructure projects such as the construction of the Baird train Shinkansen and the airport are included in the totals. The most successful conciliation experience was the Teshima case. In Teshima Island, in the Seto Island Sea, approximately 500,000 tons of vehicles and shredded dust had been illegally dumped and incinerated for over a decade. The waste was contaminated the island soil and the surrounding marine area, and the cleanup cost was reportedly estimated to be at least 30 billion yen, around $2,200 US. A total of 549 local residents filed an application for conciliation against the polluters, the waste generating companies, and the local government who neglected to control the violator. Local residents demanded compensation, the removal of all illegally dumped waste from Teshima, and restoration of the site. The EDCC appointed 3 technical experts to investigate the pollution of the site at its own cost, which came to 236 million yen. On 6 June 2000, their parties accepted the conciliation with a pledge to build a new treatment facility of waste in Naoshima, a small island next to Teshima. The costs were covered by the state, prefecture, and waste generating companies because polluters didn't have money to clean up. The EDCC followed up the process to secure appropriate treatment of waste. In addition, the Teshima case led to revised of the waste disposal and public cleaning law, which strengthened the liability of violators. This example illustrates how an administrative ADR can complement the legal system with a flexible solution that promote environmental policy. Now I will come to the challenges and the future perspectives of the EDCC system. The EDCC was established 50 years ago. In the past, conciliation has been most frequently chosen by applicants. However, recent data indicates that the EDCC is moving towards a more adjudicatory model. Although no environmental court exists in Japan, ordinary courts can utilize the knowledge and expertise of the EDCC by commissioning adjudications. The administrative ADR, especially the EDCC, also have some measures to reflect their knowledge and experience in environmental policy. However, EDCC also faces some challenges. First, its jurisdiction doesn't cover all environmental issues. The EDCC has handled cases flexibly, including disputes involving pollution other than the typical major types of pollution, as long as the case is related to pollution. However, it could be difficult for the EDCC to handle a genuine biodiversity cases. Therefore, it is worth considering expanding the jurisdiction of the EDCC and review boards to encompass all environmental dispute. Second, there are cases in which it is difficult even for the EDCC to clarify the causal relationships, such as disputes concerning chemical high hyper sensitivity in the ecosystem. In such cases, it is necessary to reduce the burden of proof, for example, by applying the precautionary principles. Some environmental courts in Asia, as well as in other regions, have special procedural rules for environmental litigation, and that stipulates application of environmental principles, including the precautionary principles. Internationally, the application of the in dubio pro natura principle has been discussed. It has already been applied in some Latin American countries. In this context, it would be useful to refer to international developments on ECTs and to share their knowledge and experiences with each other. Thank you for your attention.
Thank you so much, Professor. I think I was aware of the limitations in Japan around standing in courts, and it's really heartening to hear that there are alternative mechanisms for responding to disputes, in particular that they can enable faster responses, which I think is something that's really critical in the modern age, and more flexible responses to environmental disputes. I also agree that it's really important to consider an expanded jurisdiction which might enable greater consideration around biodiversity cases. So thank you so much for such a wonderful presentation. Okay, so moving to our next speaker, Associate Professor Yuhong Zhao. Sorry about my pronunciation. Yuhong is an associate professor at the Faculty of Law at the Chinese University of Hong Kong, and she specializes in Chinese environmental law, climate law, and policy and comparative environmental law. And her teaching expertise includes Chinese civil law. She's published in prestigious peer-reviewed law journals, including the Chinese Journal of Comparative Law, German Yearbook, Book of International Law, the University of Pennsylvania, Asian Law Review, and so forth. Her latest work is Chinese environmental law with the Cambridge University Press. She also serves on the editorial board of the Chinese Journal of Environmental Law. Professor Zhao will be looking at judicial responses to the environmental crisis with a study of ECTs in China. Given what Linda has told us about the growth in ECTs in China, this should be fascinating. Associate Professor, the floor is yours.
Thank you, Chair. Thank you, Briony, for your very kind introduction. Now, I'll share my screen. Can you see it clearly?
Yes, I can. If you could just go to presentation mode, that would be wonderful.
Right. Thank you.
Right.
And before I start, I would also like to thank Linda for inviting me to be part of this project. It's my absolute pleasure and honor to contribute a chapter on ECTs in China. So in this presentation, I would like to, first of all, discuss about the emergence of ECTs in China, focusing on local ECTs since 2007. And after about 7 years of exploration at the local level, we have seen this very important judicial reform led by the Supreme People's Court to further develop this specialized environmental adjudication. And I will conclude the presentation with some discussion of the prospects of ECTs. And a very quick snapshot about the courts in China, that is, they are organized or structured in a hierarchy of 4 levels. And at the very top of the hierarchy is the Supreme People's Court. And then we have got Provincial High Court. And below it, Intermediate Court and the Basic Level Court. And very different from many other jurisdictions, especially common law jurisdictions. The courts in China operate in specialized divisions, and they are divided into civil, criminal, administrative, and enforcement divisions. So this is the operation of general courts in China. And then the question is, why ECTs? Why specialized environmental courts? It has something to do with China's environmental degradation after more than 2 decades of economic growth since 1980s. And during those 2 decades, although we have seen the development of environmental legislation, but somehow the enforcement, the implementation and enforcement of environmental rules had not been that effective. And therefore, as a result, people started to feel the pain of this the byproducts of economic growth. And that is, we have seen start, especially in the first decade of the 21st century, we have seen this increasing trend of environmental violations, growing number of environmental disputes, and they are statistics released, official statistics, to say that they are such high number of environmental disputes being complained to different organs and institutions by letters, visits, and telephone hotlines, and that was the record show it's over 100,000 per year, but very, very tiny percentage, less than 1% of those actually ended up in court. And so how do people resolve their disputes? Many ended up in forms of protest, public protest, violent blocking of those factories, the polluters, by victims of pollution, or residents affected by pollution. And so there was this very general public dissatisfaction with the existing judicial practice, the performance of the court. And lawyers, environmental lawyers, victims of pollution, environmental NGOs frequently express their frustration with their experience at court, and they summarize that into 3 difficulties, namely, it is difficult to have the case accepted by court, and it is very difficult to win environmental litigation in court. And even if they have overcome all the hurdles and managed to get favorable judgment, they still face the next difficulty of actually having those judgments enforced. So against this background, there was also wide discussion among academics and practitioners about the potential function that may be offered by perhaps specialized environmental courts. So there was high expectations of specialized environmental courts to deliver environmental justice, as discussed earlier today in the first session. That is, it was hoped that perhaps the newly established ECTs can offer easier access to justice by victims of pollution, and also to those environmental NGOs in fighting legal battles to protect the environment. And ECTs may offer this judicial redress in a timely manner instead of long delays, as in those general courts. And there was also high expectation of improved quality of judgment, because it was expected that judges in ECTs, they accumulate their experience and develop special expertise and show their special knowledge and sympathy to those environmental claims. And in addition, as we have seen in those environmental cases, very often one pollution incident may very often attract different types of liabilities. So the polluters may, in violation of environmental laws, may be pursued for their criminal liabilities, and at the same time they cause damage to the environment and cause harm to property of those victims of pollution, like farmers and etc. So they are potentially liable to pay compensation. So in traditional Chinese court, these kind of claims, they have to be handled by different divisions, criminal division and civil division. So if we can combine them into one single trial by one collegiate panel to decide on different liabilities, that can also improve judicial efficient use of judicial resources. And in addition to these more specific purposes and benefits, there is a more general role for the courts to play in building environmental governance in China. So with all these expectations, we have seen the emergence of local environmental courts since 2007. And these are the 3 very important courts that have engaged in early exploration of specialized environmental adjudication. And we can easily note that all of these courts were established in response to serious local water pollution crisis. So the first one was established in November 2007 in Guiyang, actually in Guizhou province. This initial exploration includes 2 courts. As I just explained, courts are divided into 4 levels in China. So they believe it is important that we have both the basic level environmental courts and intermediate level Guiyang intermediate court. So that, and also in China, 2 trials conclude a case. So Qingzhen Environmental Court, here environmental cases as first instance court, and all the appeals will go to Guiyang Intermediate Court. And they were set up with the very special mission to protect water resources in the so-called 2 lakes and 1 reservoir. They provide important sources, drinking water supply for over 3.9 million residents in the city of Guiyang. Similarly, in 2 other provinces, Yunnan and Jiangsu provinces, we find specialized courts set up at Wuxi Intermediate Court in response to the blue algae outbreak at Lake Tai, repeatedly for many years. So in the end, they decide to set up this, this pollution, this environmental disaster was caused by the polluters located around Lake Tai, discharging wastewater, industrial wastewater to the lake. And the third one, in Kunming, at Kunming Intermediate Court, was set up in the aftermath of this arsenic contamination of Yangzhonghai Lake. Again, in both, in both provinces, Lake Tai and Yangzhonghai, they also provide the source of drinking water supply for local residents. So how different are these environmental courts from general courts? One significant difference is, of course, their jurisdiction. So they combine civil, criminal, administrative, and enforcement jurisdiction into that one court, one division. And this photo is Qingzhen Environmental Court. This court was further granted a special jurisdiction, or also known as designated jurisdiction, to decide on those environmental disputes or pollution cases involving the 2 lakes and 1 reservoir, even if the polluters are located out of Guiyang. So it was quite significant at the time for court to have jurisdiction beyond the original administrative boundary. So secondly, and I think it's also very, very important, speaking of the role and the contribution of these ECTs, is the development of environmental public interest litigation. So they have, in all 3 courts, they have developed special rules to relax standing, to allow these bodies, including statutory bodies, NGO, EPB, Local Environmental Protection Bureau, and Procuratorate, to file cases or public interest litigation cases to protect the environment, either against polluter or against agencies. And in addition, and according to those environmental judges, they do have different or unique attitude and passion for the environment. So, for example, like in the Qingzhen Environmental Court, judges they do get actively involved in responding to cases filed by, for example, by NGO, because in China, judges may engage in collection of evidence. So, for example, in this particular case against Dingba Paper Factory, judges on the collegiate panel for this case, actually they get to the site, to the site where the paper factory, the polluter, secretly discharge wastewater into Nanning River to collect evidence, to take photos, to collect samples. So that's what they did. And you can't expect judges from general courts to engage in this kind of very responsive acts to NGOs. So we do.
Sorry, Professor. I was wondering,
yes.
We've gone over time, so if you could wrap up, please. Thank you.
Okay, so although there are disparities among these early practice of different courts, and some are more successful than others, like this Qingzhen Court, more successful than Kunming Environmental Court, that are struggling with small caseload. But jointly, they have accumulated judicial expertise for legislative reform and also for more specialized environmental adjudication that happened at the next stage since the year 2014. And this is led by the Supreme People's Court. And they have played important leadership in institution building since 2014, and also through the promulgation of judicial interpretations and guiding cases to promote innovation, judicial innovation in jurisdiction, in adjudication, in producing judgments that are more flexible and creative. So how many minutes do I have now?
We're actually over time by a couple of minutes, so if you could provide your concluding remarks, that would be wonderful.
All right, good. So as you can see, we have seen this more strategic development of environmental courts based on the lessons learned in the first phase of local exploration. Instead of increasing the number of environmental courts, using Jiangsu province as an example, they actually cut their specialized environmental courts from 45 to 11, and to establish this 3-level, from high court to intermediate court to basic level court, that they can develop centralized and comprehensive jurisdiction. And in order to address the problem of independence, we understand that Chinese courts, they have to operate within the constraints of the political and legal constraints. So they have tried their best to innovate in jurisdiction like this cross-provincial jurisdiction to try to avoid local protectionism. So By special designation of the Supreme People's Court, it led the Intermediate Court in Beijing to hear appeals of environmental administrative cases in Tianjin. And so I'm not going to further details to the innovation in adjudication and also more flexible creative judgment. But I would like to wrap up this presentation with some prospect for the future of ECTs in China. That is, will ECTs be able to respond to global environmental challenges, to respond to global environmental crises, including biodiversity loss and climate change. And we have seen emergence of public interest litigation filed by Friends of Nature to protect the habitat of green peacock, and also to promote renewable energy. So although these they have encountered extreme difficulties due to the gaps in legislation, but we do have high hopes of this continuing exploration and development of ECTs in China in response to new challenges. Thank you very much.
Thank you so much for such an enlightening presentation. I think the thing that seems to be really critical that we hear time and time again, and especially in Asia and the Pacific, are the pressures for economic development and the impact that has had on the environment, and the importance of providing easier access to victims of environmental damage, because they obviously often need support. They need the rights of access, but we also need more responsive remedies. Time is important. We can't wait 8 years for a resolution, and damages aren't always the appropriate resolution. So we need that flexibility. So thank you so much for that enlightening presentation on ECTs in the PRC. I'll move to our next and last speaker is Alan Webb. Alan is a barrister based in Auckland. He specialises in environmental law issues in New Zealand and internationally, and has over 28 years in litigating company contract, commercial, negligence, property, resource management, and land disputes. Alan focuses predominantly on environmental issues arising under the Resource Management Act 1991 for New Zealand, and he has acted importantly as amicus curiae on several occasions upon appointment by environmental and district courts. Alan also undertakes environmental due diligence and auditing services, and undertakes pro bono work on a case-by-case basis. He's here to discuss environmental adjudication in New Zealand, past, present, and future. Alan, the floor is yours. Do we have Alan with us? I can't see him here.
Yes, I see his name.
I'm here.
Oh, there you are.
There you are.
Yeah, we can't see your camera, Alan. Sorry.
Yeah.
There you go. Yes.
Kia ora, from New Zealand, and I've been listening to the presentations, the last three presentations, absolutely fascinating. I have to apologise. This presentation isn't as polished as I would have hoped it to be, because I'm actually a last-minute replacement for His Honour Judge Newhook, who was slated to speak to this evening. He had an unavoidable conflict with some travel, and he just was unable to make it, and so he does send apologies. So I have got some material that His Honour has produced, and I've also got my knowledge of the environment in New Zealand. Apologise, I just haven't been able to translate that into any against me. But thank you very much for inviting to talk to you about environment courts. I must say, we do feel a bit like the old person in the room, because we've had environment courts in New Zealand, one shape or another, since about the 1950s. And the environment courts have been central to environmental adjudication issues in New Zealand, which cover a broad spectrum of cases, I suppose, if I can put it that way, that can be brought before the Environment Court. So I just want to tell you a little bit about how our Environment Court is composed and where it comes from, and then I'll tell you a little bit about its jurisdiction, and then I'll tell you a little bit about some of the challenges that it's been facing. And look, I'll rattle through all of this really quickly because I know that we are up against the clock. But the Environment Court in New Zealand is a creature of statute. Briony mentioned the Resource Management Act 1991, and that act is what creates the Environment Court, and it sets out the composition of the Environment Court and the jurisdiction of the Environment Court. And I suppose a couple of points from that is that because it's a creature of statute, the Environment Court doesn't have any inherent jurisdiction. And that means that it's a reactive court rather than a proactive court, in the sense that the Environment Court can't initiate any actions against a particular party. It can only adjudicate on proceedings that are brought before it. So that's not necessarily a bad thing, because it still enables the Environment Court to have an overview of an environmental issues according to what's going on in particular in New Zealand. The Environment Court, there's one Environment Court in New Zealand, but it has three different bases, if that makes sense. So I've got a base in Auckland, a base in Wellington, and a base in Christchurch. And we have 10 permanent, or we can have up to 10 permanent Environment Court judges. And I think currently there's 9. And all of those judges are, like me, they were previously lawyers who acted in the resource management field. And so we use the phrase environmental adjudication or resource management work interchangeably. They mean the same thing. So the judges are, you apply to become a judge, and then you're appointed by the Attorney General. There's one chief judge, and there can be up to, I think, 3 alternate judges. And so Judge Newhook, for example, used to be the chief Environment Court judge, and now he's retired, in inverted commas. I think he's busier than ever, but now he's an alternate Environment Court judge. So the alternate judges pick up the slack, if you like, if the other judges just don't have time to hear matters. And when the Environment Court sits, there's always at least one judge, but they usually sit with 2 commissioners. And commissioners are fairly senior people that are experts in a particular discipline. So they could be engineers, they could be planners, they could be landscape architects, they could be noise consultants, they could be traffic engineers. So that when a case that involves, construction and planning issues, the Environment Court might seek to have an engineer and planning commissioner sit on the court with him or her. And in the work of the Environment Court, it operates as an appellate jurisdiction. So without going into too much detail, New Zealand's divided into a number of territories that are run by councils. And in each territory, the council produces what's called a district plan. And the district plan sets out the rules for what activities you can do as a permitted activity or ones that require resource consent in that territory. So that, for example, if someone wants to undertake a big development in Auckland, say they want to build a new hotel, or they want to build a series of apartments, or they want to add on to the airport, or they want to do something in the coastal environment, they'd normally have to get what's called a resource consent. And that's an application to the council for permission to do that particular activity. Now, if the council grants the resource consent, well and good, But if the council doesn't grant the resource consent, then that person has a right of appeal to the Environment Court. And so the Environment Court will consider that person's application according to what's in the district plan and decide whether or not that resource consent can be granted and that activity can continue. Now that's a very, very simple analysis of the work the Environment Court does. But if we go back to the Resource Management Act, or we call it the RMA, that sets out the matters which the Environment Court must also consider when it's considering an appeal on a resource consent application. And the guiding principle in the RMA is that there must be a sustainable use of natural and physical resources in New Zealand. So that, for example, while someone might want to build a large hotel on a beautiful beach in New Zealand, the Environment Court will consider whether the fact that it's a beautiful beach and it will ruin the landscape values of that beach should outweigh the ability of someone to put a big hotel there. And it's that sort of thing that the Environment Court deals with on a daily basis. And also when councils draft their district, so when they set out the rules by which everyone has to act, and that has to happen every 7 years. The district plans are supposed to be renewed every 7 years. When a district plan is being formulated, if someone doesn't like what's in the district plan, they can also appeal those provisions to the Environment Court. And so the Environment Court will then be able to determine what form a district plan takes. So you can see when I mentioned earlier that the Environment Court has an important oversight role in New Zealand. It has an oversight role in terms of the rules which conduct which activities can be conducted in New Zealand, and it has an oversight also of whether a particular activity does or does not meet those rules. So that's the fundamental job of the Environment Court, but it also has other limbs to its jurisdiction. And it can, for example, you can seek a declaration from the Environment Court. So if two parties or someone in a council are at odds about whether a particular activity requires a consent or something, or another question of law, you can file what's called a declaration proceeding in the Environment Court, and it will give you the answer, and then the parties will proceed accordingly. It's also got an enforcement role. So in New Zealand, we've got two different procedures. If you see someone doing something without a consent, so if they're doing something that's causing pollution, or if they're doing something that they needed a consent for but don't have, you can make an application to the Environment Court, and the Environment Court can issue orders preventing that activity from carrying on. And then the third thing that the Environment Court does is it determines, well, they're quasi-criminal, but it determines offences for breaches or charges for breaches of the RMA. So in New Zealand, we've got a separate criminal regime, but there's also a regime where you can be punished, and they're serious penalties. You know, there's $600,000 or up to 3 years imprisonment if you do something in New Zealand that's in breach of the RMA without a resource consent, and particularly if you cause an adverse effect. So if you're operating a business near a river, for example, and you either intentionally or accidentally discharge some contaminants into the water, which has a serious adverse effect on the river, then the council can prosecute you for a breach of the RMA, and that's heard by the Environment Court as well. And I heard one of the presenters earlier, and I do sympathise, I think it was the previous presenter, with you, where it's difficult when you've got different courts dealing with environmental issues, whereas in New Zealand, they all come under the jurisdiction of the same court, and it's an excellent model. And you know, any initiatives you have to induce that model, I think are well worth it, because the Environment Court in New Zealand is widely regarded by all the other courts, including all the senior courts, as a specialist jurisdiction. So the Environment Court only hears environmental issues or resource management issues. It doesn't hear anything else. It doesn't hear any contractual issues or commercial issues or family law issues or anything like that. It's solely focused on environmental issues. And it's got a slightly different way of approaching things than say, a criminal court, so that the rules of evidence are slightly more relaxed, and there's mainly only expert evidence. So there's not a lot of non-expert evidence in the Environment Court. So the Environment Court's got its own procedures, so that if you've got a case and often there's a number of parties to a case, you might have 5 experts on each side. The timetables are worked out whereby every party files their expert evidence in advance, so that the applicant would go first, and then the council would go second, and any people opposing it go third. And the Environment Court pre-reads all that evidence, so that when you turn up to court, the Environment Court, everyone knows what's going on, and we can really shorten the hearing time by simply getting into questions and cross-examination and then determination by the Environment Court. So I'm sorry, but I'll leave that section there. I just wanted to say that the resource management, in my view, has been working really well in New Zealand, but a big criticism in New Zealand is that it can take so long for a resource consent to be granted, because there's normally 2 stages. First of all, you apply for consent to the council, and that can involve a hearing. And then if you lose that, then you can apply for, then you can appeal that to the Environment Court. Now that process can sometimes take anywhere between 12 and 24 months. So that if someone wants to build a hotel, they can wait up to 2 years before they find out finally whether or not they can get consent to do that or not. And there's been a lot of criticism of the RMA in New Zealand about that holding up development and holding up initiatives and slowing the country down, even large infrastructure projects for roads being held up. So the current government has undertaken a massive review of the resource management legislation and decided that it's going to replace that one act with 3 new acts. And they think that doing that will be able to streamline the work of the Environment Court and speed up the way that consents are granted, so that building and other work can get on more quickly. So over the years, you can imagine since 1991, the Environment Court's built up a lot of jurisprudence, so that a lot of the sections in the RMA which give the court some discretion have been well litigated now, and everyone knows what those sections means. So we're going to be confronted very shortly. The legislation is supposed to be introduced into Parliament, I think literally next month. And so we now, as practitioners in New Zealand, will have a whole new regime to deal with and respond to. The Environment Court is proposed to be retained, and it's proposed to be retained as a specialist jurisdiction, but I think the processes and the rules against which applications are considered will be fundamentally different. Briony, I don't know, I can carry on or I could leave it there. That might be a nice place to round this off. But I'm happy to answer any questions or anything like that. So it's just a quick fire summary.
Yeah, I think that'd be great, because we're at time anyway, and we need to be in the next session in the next 5 minutes. So thank you very much. I do have a number of questions as well, and I think it's I liked your comment on the criticism and the time that it takes for resource applications, which, you know, we also want to enable parties to be able to take reasonable developments, but you know, the capacity of courts to bring in specialists as well, and to be pre-prepared, I think, is a really critical aspect that ECTs make access and justice fairer. So, so thank you so much, Alan. Now, we have to be in the next session in 7 minutes. I just had one question. Linda, did you still want to ask that question? If so, I will get you to ask it, and then we can wrap up the session and then move, or maybe give everyone a break before we move into session 3. Linda, over to you.
Yeah, thank you, Briony. My question is for Yu Hong, I think, because there are so many ECTs in China. I'm just wondering, are there indicators to be called as an ECT, and how big the area would be? Is it administrative based, like village or regency, or more ecological region based?
Thank you, Linda. So perhaps I'll start with your question on definition of environmental court, or by reference to those statistics data released by SPC in the white paper, the annual publication of white paper on environmental resources adjudication. It's broadly defined. ECT include environmental and resources divisions formally established within 4 levels of court, but it also includes specialized environmental collegiate panels and specialized environmental court or environmental circuit court established by at the basic level people's court. So it's a broad definition. If we just focus, because when SPC released the white paper, they use this very broad definition. So all the data includes these. So when I mentioned we had more than 2,000 ECTs by the end of 2021, they include all of those forms. Initially, in the very first period of local exploration, they were established at those local levels. Like I'll just use Qingzhen as an example to give you some idea about the coverage. So Qingzhen is a county level city. It used to be a county in rural China, but in the process of urbanization, we have many counties like Qingzhen. They were later called city, but administratively they are county level city. So they established basic level court. And in Qingzhen, they have a population of 500,000, and it covers this geographical area of less than 1,500 kilometers. So that's the initial practice. But then after years of experiment, for these local basic level courts to set up environmental courts, they encounter difficulties having very small caseload. So that's why in my presentation for the second stage of development, we have seen like in Jiangsu province, they have actually cut down the number of ECTs because not
University of Singapore.
Because
the presentation.
Sorry, Alan, you're no longer on mute. If you could please mute yourself.
New Zealand.
Actually.
Yeah.
Hi,
so
Alan. Hi, Alan. Could you please mute yourself?
So not every single basic level court will be able to receive adequate number of environmental cases to maintain their operation. So that's why there was improvement over this earlier practice. And in Jiangsu, so they later set up ECTs based on so-called eco-environmental function zones. So For example, they set up an environmental court on Lake Tai in order to protect the eco environment, the water quality of Lake Tai, and they set up 2 specialized basic level courts to the north and the south of Yangtze River. So it's based on region to best protect the ecosystem. And for each of those basic level courts, they actually cover several counties or cities. So this is in response to the lessons learned in the first phase of development. I hope that clarified a bit your.
Thank you so much. That was really enlightening. And thank you to all of our 4 speakers. Unfortunately, we have run out of time for this session and we need to move to session 3. But to all of the people who are still with us, you can ask more questions in the Q&A in that session. So we now, with that, I draw session 2A to a close. Thank you so much to each of the 4 speakers. And thank you to everyone who joined us, and see you in session 3.
It's 3:40, so we can slowly make a start. I think people are still trickling in from the main room, figuring out all the breakout rooms business, but hopefully we will have everyone here soon. Geeta, are you ready? I'll just introduce you, but you're up first if that's okay. Okay, thank you. Hello, everyone. Welcome to panel B. We have 4 speakers in each of panel A and panel B. You are now in panel B. You can switch using the breakout rooms button at the bottom. Thank you for joining. And wow, that was a great first session. I thought lots to think about, lots to chew on. And I'm sure this panel will be as good. So we have 4 speakers today. Professor Gitanjali Gill, Peishuan Chang, Griselda Mayo-Anda, and Kokila Konasinghe. So I will introduce them in that order. It's very simple, straightforward program. So I'll just introduce them. They talk for about 15 minutes, and then at the end we take questions. So without further ado, I'll start off with Professor Gitanjali Gill, who is a tenured full professor of environmental law at the Faculty of Law, Northumbria University, Newcastle, UK. Her research interests and published work form a coherent body reflecting thematic issues, including climate change, access to environmental justice, SDGs, and sustainability. Professor Gill is a recipient of prestigious research grants. Her initial British Academy grant examined the casework and environmental jurisprudence of the National Green Tribunal of India, or NGT for short. In 2017, her research findings were published in a book called Environmental Justice in India, the National Green Tribunal, Routledge Earthscan. In 2019, the book was published in Chinese. Her recent grants include a BA award for land acquisition, rehabilitation, and resettlement of vulnerable communities in Gujarat. In 2022, she was awarded a National Environment Research Council grant on climate change and the decarbonization agenda. She acts as an expert academic advisor to prestigious international organizations, including being the National Rapporteur on Global Climate Litigation India at the Sabine Center Peer Review Network on Climate Change Litigation, Columbia Law School, New York. So clearly someone with extensive and diverse experience in the field of ECTs. And yes, like Professor Gill's presentation, the 4 in this panel will focus on countries or regions, unlike the previous presentations, which were sort of dealing with ECTs more in general. So without further ado, over to you, Professor Gill. I look forward to your presentation.
Thank you, Sauron. Thank you, APCEL and the organizers for giving me an opportunity to share some thoughts, which I'll be specifically focusing on the National Green Tribunal of India. I'll start sharing my screen now. So, can you see it? Is it okay?
Yes, we see it.
Okay.
We also see some icons below, but that's okay. It's still large enough.
Just a moment. Okay, I need to just bear with me. I'll
No problem.
Yeah, just give it to me. I'll just bear with me for a moment, please.
Sure, take your time.
Yeah. Okay. Sorry about this, but
No problem.
let's see. Okay. Can you see it?
Yeah. And if you, yeah, perfect. Full screen and everything.
Sorry about this, but today's presentation focuses on India's National Green Tribunal, QOVADIS. I have made my presentation by just slightly introduce a small introduction, then the phases through which NGT has evolved. For the purposes of ease, I'm using the word NGT, that signifies National Green Tribunal. The challenges, and that's where my focus of my talk is going to be. And finally, just a concluding remark. India took the pride as one of the developing countries to take the lead in terms of establishing the National Green Tribunal. The establishment of the National Green Tribunal essentially was triggered by factors that included access to justice, speedy justice, and more importantly, the limitation of the Supreme Court in terms of handling environmental cases that involved questions about science and scientific uncertainty. Environmental problems are polycentric, interdisciplinary, complex, and often transnational in nature. It was because of the limitation of the judges, the judiciary, to really understand the matters. There was a huge debate which went on in the country, and in 2003, the Law Commission of India came out with a report where they strongly recommended for a dedicated court to be established in relation to environmental matters. Consequently, though it was not a court created, but it was a tribunal which was created under the National Green Tribunal Act of 2010. The tribunal, as everyone knows, India is a huge country with different sorts of challenges. The principal bench was created in New Delhi, which covers the northern part of India, whereas the regional benches covered throughout India, covering the southern part, the western part, central part, and eastern part of India. The evolution of NGT, as I stated, started in 2010, and it's still an evolving adjudicatory body. According to my research, which has been going on for nearly 10 years now, more than 10 years since the time it was established, NGT has come into existence in 3 phases. The first phase is from 2010 to 2012, the second phase from 2012 to 2018, and the third phase is the present phase, which started from 2018 onwards. From 2010 to 2012, the NGT as a body was established, benches were established, but there was a lot of hesitancy from the government or from the state governments in relation to real establishment of this tribunal. And probably the reason for this sort of a thing was essentially that the administration or the executive failed to appreciate that there were some sort of green issues or environmental issues that needed adjudication. Consequently, there were issues about resources, understaffing, infrastructure facilities, and eventually Supreme Court of India had to intervene into the body by saying it's an utterly disgusting situation. There's a need to address environmental issues, and therefore the NGT has to be established. The second phase started from 2012 to 2018. And this was a golden phase of the National Green Tribunal. And the reason why I say that it is a golden phase is there was both the substantive expansion as well as procedural innovation in terms of dispensing environmental justice. The substantive features include that this tribunal was the first of its kind, which was dedicated only for civil cases, where it related to adjudicating the enforcement of environment and legal rights. The preamble of the Act and the judicial decisions recognize the right to environment as a part of right to life. Fast-track court, speedy justice, within 6 months, the matter had to be sorted, was taken up by the court. Similarly, the jurisdictional part also increased tremendously. The NGT expanded itself in relation to original jurisdiction, appellate jurisdiction, and special jurisdiction. And Schedule 1 of the NGT Act laid down the legislations under which it had the jurisdiction to entertain the matter. But importantly, the most important thing was, if it involved a substantial question of law, the jurisdiction of the NGT came into picture, which involved direct violation of the statutory environmental obligations or environmental consequences which related to a specific activity. Standing was given the most liberal interpretation, and standing has always been an issue throughout the world as to who gets the right to go to the court. And that's where the procedural part was coming up. But this standing by the NGT was given a very liberal interpretation following the concept of public interest litigation, which the Supreme Court of India had initiated. And there were 2 reasons which were given. Most of the people who go to the courts belong to the marginalized communities. Their inability to travel to the courts, their inability to have access because of resources and illiteracy. So anyone on their behalf can file the court. Anyone who is directly or indirectly affected can approach the tribunal, subject to the fact that it involves a substantial question of environment which impacts on the lives of the people. And the second reason was that the Constitution of India mandates a fundamental duty on the citizens to protect and improve the natural environment. Another reason, another way of substantive expansion, and what Chief Justice Brian Preston was talking about was in-house expertise. Judicial and scientific members sat together on the bench with a homologous standing and adjudicated the matters. Experts were considered as central and not marginal in the decision-making process. So what we saw during that time were beautiful judgments coming up, which clearly showed a symbiotic relationship, which I term it as scientifically legal judgments coming up. Epistemic community, as what Judge Preston was talking about, based on knowledge, experts came up, and there was an interdisciplinary decision-making taking place, which was basically not only sending a very strong message that this tribunal has the expertise to handle environmental disputes, but it also was providing that it's a problem-solving tribunal which is looking into wherever there are gaps in law, science is fitting into it and giving its feedback to bring about a change in that regard. This was supported by the application of fundamental principles of law, which are enshrined within Section 20 of the NGT Act, that is the precautionary principle, polluter pays principle, and sustainable development. These 3 principles are considered as mandatory in relation to deciding environmental disputes. Importantly, this tribunal was given the power of merit review. It was given the power to see that not only look into the in-depth scrutiny of law, but also the technical evaluation underpinning a decision. The reason again is environmental matters are so complex and so scientific that you need that sort of an expertise to look into the matter. And this helped within the judicial application of the fundamental principles, particularly the precautionary principle and the polluter-pays principle. Innovative procedures came about, investigative procedure in the sense that the litigation in the NGT is just simply not adversarial, but it is investigative, where the members, especially the technical members, can take up inspections that allows them to compare and contrast contradictory claims and reports that are being filed by the parties. Suo motu power, the controversial suo motu power. In the morning, Michael, it's being talked about. Matthew has talked about suo motu, and Briony also said it's a good practice of suo motu. I do have a reservation on that. Stakeholder consultative process, that all the stakeholders were involved in decision-making and the court was monitoring. India has a severe problem of implementation. So stakeholder was involved. Process where all the parties were brought together, regulatory parties, all those people who are involved in decision making, and it served twin purposes. Number one, it made the authorities admit the fact that there is an environmental problem and that needs to be solved. And number two, time-bound solutions have to be involved in order to solve the problem. But this stakeholder problem came up on pan-India issues, like air pollution or water pollution, where the larger interest of the society was involved, which was impacting on public health and environment. Such kind of a stakeholder process gave greater element of consent to the decision-making that was being done by the tribunal. The third stage is the present stage from 2018. The focus is now on the enforcement of NGT orders. A lot of substantive environmental jurisprudence developed from 2012 to 2018, but the question was, how are we going to enforce these orders? There are issues of governance and implementation, and therefore there is a need to find solutions to implementing problems. So there has been identification of priority areas like air, rivers, solid waste management, illegal mining, hazardous industries, because time and again, the NGT is saying that there has been a repeated failure in carrying out the directions that has been issued by the NGT in that regard. One technique which has come up is constitution of monitoring committees. At present, there are more than 180 monitoring committees that have been established. They review, monitor, and implement the environmental reports, prepare suitable time-bound plans, and these are submitted to the tribunal for implementation. In addition, there is the use of technology, which is in the form of e-filing. You can go to, through e-filing, you can file the petition part, and that will be taken up by the NGT. Geotagging for evidence purposes, video conferencing, particularly it was helpful during COVID times. If you look to this tribunal, it seems to be a role model, particularly for the developing countries. It had an international reputation because it was all about the best interest of the people, the public, the environment. It's trying to maintain rule of law, access to justice, fairness, independence, impartiality. And over years, now it's been 12 years, on 1st of October, NGT will be completing its 12 years. It has really gained public confidence and recognition. But, and that's where I'm really going to focus, but there are challenges. 12 years is a long time for an institution. No system is perfect, you make it better. And what we've seen in these 12 years is that over a span of time, there are challenges that have come. The first challenge which is coming is bench membership. And this has to be fully addressed. Section 4 of the NGT Act says that there should be minimum of 10, but maximum of 20, both the expert members as well as judicial members. The availability of spectrum of scientific knowledge reflects a wide ranges of cases that can be heard by the NGT. And a balanced bench is fundamental in dispensing away with environmental justice. On one hand, too many judges can really stifle the process, but on the other hand, the limited number can have an impact on environmental decision-making. What we are seeing now is a limited bench in its form. Since 2017, there has been a limited number of judges. In 2021, there were only 5 judicial members and 4 experts. And as of today, there are only 7 judicial members and 6 experts. So this sort of a limited expertise is having an impact on the delivery of environmental justice. We need a balanced bench in order to provide a scientific perspective that generates hypotheses about environmental events and processes and provides an evaluative statement to compare possible options to support environmental decision-making. But what we find is a limited bench which is unable to handle these kind of matters. And this is one of the challenges that has to be addressed for the success of the functioning of the NGT. The second one is talking.
Just to quickly remind you, we are about 2 minutes left on the clock. Yeah, thank you.
Yeah, the exercise of jurisdictional power. In the morning, Justice Preston talked about, do ECTs deliver justice? How are laws applied? And I think the efficiency, effectiveness of the NGT is getting affected because the judgments are lax, unsophisticated, and open to question. There is a non-application of mind, no reasoned orders are being passed, and increase of appeals is there to the Supreme Court. And time and again, Indian Supreme Court has criticized now the NGT on its decision-making. For example, in Hanuman Lakshman Arsarekar case in 2019, the NGT did not exercise its merit review, and the Supreme Court said it has failed to discharge its essential function. Similarly, again in a Tamil Nadu case, it exceeded its jurisdiction and it did not apply its mind. Again, time and again, this is coming up where they are saying that they are not properly using their mind or providing reasons. For example, in condonation of delay, they do not give any reasons. They just dismiss the applications without providing reasons to the common person. And that is where the questions about effectiveness of justice comes up. Exercise of suo motu power. Sorry, and I'll just take this for a minute. This has been talked about as a good practice. I agree. It provides proceedings as flexible and tries to deal with environmental exigencies. But there is a caveat that it also opens the doors to dangers of jurisdictional overreach. There are questions that may be included about the veracity of the media source, the criteria for the selection of the case, the recognitional opportunity for the judges to become activist judges. How do you define as to what is a public interest or an environmental interest, or where the rights of the people are getting affected? For example, my research shows that from January 2020 to October 2021, in the Southern Bench, there were 66 out of the 66 cases of suo motu. 23 cases came from one national newspaper, which kept on filing the cases. What was the basis on that? Similarly, the number of suo motu petitions are coming up so high. If you look to the statistics, Supreme Court of India 1990 to 2021 has only entertained 46 suo motu petitions, but NGT bench from 2021 to 1st August 2022 has already entertained 55 cases. Where do you draw the line? It's only the principal bench and the Southern bench which is entertaining suo motu cases. The rest of the benches are not. So where is the uniformity and consistency which is coming in suo motu? No doubt it is a good practice, but then it has to be exercised with caution. Lack of clarity about fundamental foundational principles. This is such a huge problem because the understanding, appreciation, and the application of fundamental principles is so inconsistent, unpredictable. For example, if you read to the judgments, Indian judges are very fond of applying precautionary principle, polluter pays principle, without really understanding as to what these principles mean. And if you read the judgments, you would find there is conflation of precaution and prevention. When do you say it is scientific uncertainty or uncertainty? When do you say it's a harm or a serious harm? Similarly, for polluter pays principle, the words are being used overlappingly, which have got a very different connotation. Restitution, restoration, rehabilitation, remediation. These words are malleable and they can be overlapping. But the judgments are showing that these judges are just, because they are fond of applying these principles, they just use it without a real clear understanding of what these principles mean. So this sort of a disagreement, this sort of a non-understanding, this sort of a misapplication introduces subjectivity, which has got an impact on the rights, environmental rights, well-being, and economic development of the society. The overuse of this principle stifles economic growth, and the under-application of the principles has a detrimental effect on the environment and people. I mean, judges are wordsmiths, lawyers are wordsmiths, but we have to be careful as to when we apply these principles. The last challenge is the committees. These committees, more than 180 committees.
Sorry, Geeta, to interrupt. We have 3 more speakers and we are well over time. So if you could just quickly, thank you.
I'm just finishing off. The practical utility of these committees is is yet to be seen. Over time, and my last slide is, where are we now? Over time, institutions, personnel, and public expectations changes. NGT really needs to look into where they are going. Yes, it is a good institution, but it has to really ask very difficult questions about the real effectiveness of decision-making. So it needs a refreshing approach to respond to current challenges. Thank you very much. Thank you.
Thank you very much, Geeta, for a wonderful presentation. That's a really helpful whistle-stop tour through the 3 phases of the NGT, and also focusing on the assessment, sort of looking back, as well as the challenges looking forward. Next up, we have Pei-Xuan. Pei-Xuan, if you're ready, I'll just quickly introduce you and then we can go straight into your presentation. We will, of course, have lots of time for questions later, but I don't want to sort of slow things down just at the moment, keep the momentum going. Pei-Xuan is a PhD candidate at the Public International Law at the School of Law, Tsinghua University. Her current research interest covers international environmental law, law of the sea, and legal aspects of sustainable development. Pei-Xuan has worked with NRDC Beijing office, Greenpeace East Asia, UNDP Beijing office, and the Development and Research Center of the State Council of China, where she has been engaged in multiple projects regarding international environmental law and governance, climate change, plastic pollution, green finance, ESG, and South-South cooperation. She also served as an in-house counsel at a leading Chinese state-owned enterprise. Pei-Xuan holds an LLB degree in legal studies from China Foreign Affairs University and an LLM degree in public international law from Leiden University. Over to you, Pei-Xuan. Yeah, we see the screen, full screen. It's all good. Pei-Xuan, I think you're breaking up, or maybe not on video. Am I audible to the rest? Could someone unmute and confirm, please?
Yes,
Yes.
Ryan.
Okay. And you can't see Pei-Xuan like me, I'm guessing. Kokila, for example, do you see? I see Pei-Xuan's slide, but not her video, or I can't hear her right now.
Neither can I. Sorry.
Okay, should we, just to keep things going, Gertie, can I put you on, and then maybe we can work on Peshwan's, maybe there's a connectivity issue.
Sure.
Yeah, okay,
Okay.
sure. I'll just introduce you then. Sorry, we are just waiting for
Yes.
Peshwan. I suspect there's some kind of internet connectivity issue. So we'll just have Gertie's presentation first, and then we can have Kokila. So I'll introduce Griselda Mayawanda, who will be writing a chapter on environmental courts and tribunals in the Philippines, a legal analysis. She is an environmental attorney with over 28 years of field-based practice in environmental advocacy, education, litigation, and community-based resource management work in the Philippines. She established the Environmental Legal Assistance Center, ELSC for short, in 1990, which is now one of Philippines' most active NGOs working to empower communities and local stakeholders to protect their natural resources. She is a professor of natural resources and environmental law in the Palawan State University College of Law since 1995. She also taught legal ethics from 2003 to 2020 and has been teaching land titles and deeds since 2015. She finished her law degree cum laude in 1985 at the San Jose de Recoletos, Cebu City, and undergraduate degree in accounting cum laude from St. Teresa's College, Cebu City. Over to you, Gertie. Thank you.
Good afternoon, everyone. Thank you, Sorion, for that kind introduction. Thank you for APCEL and other colleagues for inviting me. So let me share my PowerPoint. I hope it's clear. Okay, I'll put it on slideshow. Is that clear?
Yep,
Okay.
perfect.
So quickly, modesty aside, looking through almost 30 years now of environmental cases, I've tried to group some of the things why groups, NGOs, and individuals actually litigate for themselves, for the communities, for the environment. And I'd like to start with Tonio Posa's statement that he said, we should tell a story, Gertie, on how the environment actually changed, on how, example, in the case of miners, how they represent not only themselves, but the future, and how forestry or logging is a significant issue to a beautiful country, rich in biodiversity, but threatened with a lot of environmental problems. And again, in the work that we have done with other public interest law groups and also working with government agencies, there are many cases that push for enforcement and punishment. But there are also, with the passage of the 2010 Rules of Procedure for environmental cases, there's a lot of work now seeking damages, asserting rights, compelling government to do its job, pushing for rehabilitation, and also changing behavior. Because sometimes we know that, example, for free and prior informed consent processes which are embodied in our law, there are certain nuances that local communities like indigenous peoples want to see. So there is an effort to pursue litigation in that area. Of course, it's difficult, but I would like to include that. And because like other countries in the Asia Pacific, we're very rich in biodiversity with so many protected areas and key biodiversity areas, the aim to litigate is to ensure that these wonderful biodiversity-rich areas continue to survive and enable us to become climate resilient and enable us to face the future. So just summarizing that, in the piece that I intend to contribute, I'd like to look into the opportunities, but also the challenges. And if you look at the Philippines, many experts have actually described the Philippine framework as a relatively developed approach when you talk about environmental justice. So we are fortunate. We have a progressive constitution which embodies a right to healthful and balanced ecology. We do have rules of procedure for environmental cases in 2010. In 2008, the Supreme Court designated about 117 environmental courts. These are all trial courts. And then it's also good to underscore that there are public interest law groups, environmental and human rights organizations in this part of the world, although that's also the flip side. There is a challenging journey. And it's also good to emphasize that there are continuing capacity building programs pursued by the Supreme Court, Philippine Judicial Academy, the Asian Development Bank, the Legal Education Board, and many other development partners. Okay, when we talk about framework, I'd just like to emphasize that there have been cases that the Supreme Court has ruled on, emphasizing the Constitution, our special laws, and also our rights. So just, I think, in short, if you want to ask for a law that actually protects the environment, perhaps the Philippines may have that. From ridge to reef, or for accountability, for local governance and decentralization and human rights, we would have that. And we do have mandated institutions to enforce every law. There may be overlaps, there may be challenges, but at least if we want to seek a remedy, every law and our procedure identifies that. Now, this case I'd like to share highlights how the High Court underscored the Constitution and the importance of our laws. This refers to the case of the resident marine mammals, where two lawyers, two colleagues, and also fisher folks tried to prevent the continued oil exploration in a protected area, which is the Tanyan Strait. This is they call it the resident marine mammals, but then the Supreme Court ruled that they need not give standing to the marine mammals because there were already Filipinos who represented themselves as stewards of these marine mammals. But what is important to highlight in this case is that the Supreme Court decided to pursue emphasizing the nature of the service contract, even if it was already terminated, because it was unlawful. It was not signed by the President, and it was not authorized by a general law and reported to Congress pursuant to our laws on protected areas. It also breached our Philippine Environmental Impact Statement System. So at least there are many other cases, but this is one important case where our constitutional rights and special environmental law provisions were emphasized. Okay, I mentioned about the Supreme Court Rules of Procedure for environmental cases. It was released on April 29, 2010, and so by today, it's about 12 years, and there have been discussions on whether there has been a systematic study on the quality of the implementation by our judges of the Rules of Procedure for environmental cases. So what we have done so far, me included, is to look into almost 20 cases, and then of course litigation is still continuing in the trial courts. The Supreme Court issued these rules after conducting a series of workshops and focus group discussions plus conferences to respond to the difficulties in environmental litigation in the country. Issues about delays, about cost, about standing were raised in these conferences and focus group discussions. So the rules were passed as a landmark opportunity to enable us to litigate. Plus, it relied on the Constitution, and it was supposed to facilitate and provide an enabling environment conducive for communities, civil society groups to litigate, to pursue environmental litigation. So these are the highlights of the rules. I have no time to dwell on that, but I just like to pick on important things like citizen suits. Here, you do not need direct injury. For example, an NGO can intervene or be part of a civil action that would want to stop mining in protected areas in the Visayas, even if such group may not be there. So it really liberalizes standing. And the terminology of the rules actually reflects the doctrine in the Oposa case, which is also important to point out. Another thing to note is that the payment of filing fees are deferred. So then it addresses the issue of costs. The writ of nature of the writ of kalikasan is a powerful remedy, but areas like the province where I litigate, where I come from, Palawan, cannot take advantage of the writ of kalikasan because we're just one province. The writ actually provides that the magnitude of the environmental damage is of such nature to prejudice the life and the property of inhabitants in 2 or more cities. So it's supposed to provide an immediate relief. And the right, again, to health and balanced ecology is pointed out there. Now, the writ of continuing mandamus, this can be initiated by affected or aggrieved citizens, and it is addressed to an environmental agency because we want them to perform certain acts that the law actually clearly provides them to do. So this was highlighted in the Metro Manila Development Authority case involving Manila Bay, and since then, it has been used by several citizens and groups to compel action on the part of government agencies, whether it's the Department of Environment and Natural Resources, the Department of Energy, the Department of Interior of Local Government, and many other agencies. The Environmental Protection Order, we have taken advantage of this in our coal cases, our mining cases, cases to protect our biodiversity areas, and in lieu of a writ of kalikasan in a locality, we can seek this as a remedy to integrate both prohibitive and mandatory reliefs, unlike in ordinary civil cases. And you can actually seek this even for criminal cases. And you can combine this in the special writs that I mentioned. Now, a temporary remedy, which is 72 hours, is the Temporary Environmental Protection Order. So if you look at these remedies, the objective is to enable citizens, concerned groups, to assert the rights to the environment, to protect their natural resources, and to compel government agencies to implement their mandates, and to also seek damages. The Boracay
Hi,
Foundation...
Gati, sorry
Yes.
to interrupt. Just to remind you, there's about 2 minutes left. So if you could wrap
Okay.
up after the next slide,
Yes.
maybe that would be great. Thank you.
Okay, thank you. So this case, Boracay, is important because it actually highlighted the need to do consultation. And the writ of mandamus and the writ of kalikasan was actually invoked here. Now, because I do lack time, if I may go to the challenges, because precautionary principle is part of that, I'd like to highlight the challenges. Pardon me for the lack of time. And I think these are important insights to leave behind when I contribute to that book, is that while we do have rules and laws, the challenge is that the capacity of aggrieved and affected citizens are still highly wanting. We still need more lawyers to provide legal assistance. So access to justice is still a problem. Availability of experts is still a challenge, plus funding for environmental litigation. So having explained all the opportunities, it is not enough to see that we do have laws. It is not enough that we have the rules of procedure. We have to make sure that there are people, there are citizens who are able to take advantage of these laws, these policies, these rules. Because without them, we cannot help shape the discourse, and we cannot also contribute to the growing effort of achieving environmental justice in this beautiful part of the world. So I'll end up my talk with that. Thank you for listening. And as we say in the Philippines, mabuhay.
Thank you very much, Gati. That's a great overview of the state of play in the Philippines. I think we'll just give Peshwan a bit more time. Kokila, are you okay to go next? Because hopefully the longer we wait, the more stable the internet connection will be for Peshwan.
Yes, Soren, I would be happy to come.
Brilliant, thank you. Maybe if you start setting up your slides, I'll quickly introduce you and then we can have your presentation as well. Okay. Brilliant, thank you. So Professor Dr. Kokila Konasinghe of the Department of Public and International Law is the MPhil and PhD coordinator of the Faculty of Law, University of Colombo in Sri Lanka. She is the founding director of the Center for Environmental Law and Policy at the University of Colombo, a member of the Commonwealth Climate Cohort 2021, and has been selected to present her research at the UN COP26 in the UK. Professor Konasinghe is the co-advisor for all 7 South Asian countries under the UN Millennium Fellowship Program and responsible for the South Asian Report on Climate Change and Sustainable Development Goals. Professor Konasinghe is preparing the country report on international disaster management laws and policies under a collaborative project with other SAARC countries and International Red Cross and Red Crescent Society. She's a visiting researcher and teaching fellow at Erasmus Rotterdam, University of Granada, and Jindal Global University, and also an attorney of law of the Supreme Court of Sri Lanka, and a staff and educational development association of the UK accredited teacher in higher education. She will be speaking about her area of expertise, which is South Asia. So without further ado, I welcome Kokila Konasinghe to talk about South Asian perspectives on ECTs. The floor is yours, Kokila.
Thank you, Ivan. It is my pleasure thanking you first, Royan, and also APCEL team, and also ADB team, and all the colleagues from various different parts of the world, but aligned to study on this area of environmental courts and tribunals, the Southeast Asian and the South Asian perspectives. So I was supposed to be the last speaker, so I thought that I could listen to all the speeches, but even at this moment, I can see that this book will definitely be an interesting contribution to many gaps in the literature on ECTs, because now this is becoming a very popular topic in elsewhere as well as in Asia and East Asia. So my main objective is to highlight some points, since this is a research in progress. I will highlight a couple of points from the South Asian perspectives. And after listening to Geeta, I think I might reconsider talking about India, but for the moment, bear with me, because my original abstract was on India as well. Right. So why environmental tribunals and courts? So my broader conceptual analysis towards understanding why ETCs in the jurisdictions is coming from environmental justice perspective. And this perspective itself has 2 elements, in my opinion: environmental justice to humans and also justice to the nature. And if you look at why ETCs, if I narrow it down to very few couple of points, first it's efficiency, and also expertise, and also very economic, both environmental cost and also economic cost. So then let me briefly go into few aspects of environmental justice aspects before I move on to specifically on ETCs. Delivery environmental justice within the governance framework is something that we all highlight, and the previous speakers as well in their presentations, that environmental justice was highlighted from the previous session as well. So I think I have recognized 3 points in the importance of delivery of environmental justice through environmental courts and tribunals. That is, the first one is equity in distribution of environmental risk and compensation. So when you look at the South Asian region, you can identify this aspect of environmental justice, equity in distribution of both of these aspects, environmental risk and also compensation. And also a recognition of the diversity of the participants and also experiences in affected communities. The third point is participation in the political and governance processes. And here I have highlighted not just mere participation or not the formal participation, but the meaningful participation. And delivering environmental justice through environmental courts and tribunals, I also look at from the point of view of right of nature. Perhaps this is too early for the South Asia to consider, but given the fact that some of the high courts, like Uttarakhand High Court in Muhammad Salim and other cases, they have considered these rights of nature element in delivering environmental justice to nature. So I thought that perhaps even it is relatively earlier when you consider other parts of the world, but I thought of including some aspects of rights of nature and recognition of legal personhood nature from the justice to nature perspective within the framework of environmental courts and tribunals. So that will be another main highlight in my chapter from the South Asian perspectives. If I may briefly go through this significance of South Asia when it comes to environment. And this region has many environmental challenges. No wonder that it is one of the best biodiversity hotspots, as well as very rich in biodiversity, as well as wildlife and many other aspects of environmental protection. And we have problems of loss of biodiversity, pollution in every other way, deforestation, adverse impacts of climate change, and many more environmental problems. And in order to address these challenges, South Asia requires expedient solution, ranging from comprehensive legislative frameworks to administrative decisions and also judicial interpretations. So all three aspects of governance I would highlight here: legislature, judiciary, as well as administration, executive. So all three branches of governance should align to deliver expedient, efficient solution with a special focus on environmental protection. And also, finally, focus on environmental justice. So the research methodology of my chapter would be mainly on a comparative analysis of ECTs in South Asian jurisdictions. And as I mentioned this is a really good opportunity for us to have a look at into others chapters. So I might reconsider taking India as a jurisdiction, and Bangladesh and Pakistan, and perhaps Nepal. So I would consider identifying best practices and also prospects and challenges encountered by these jurisdictions. And if I go into challenges and prospectus, so I might not actually, after listening to Geeta, because her paper is mainly on India, so might have overlaps with my chapter. So I might not consider this. So I will move on to Pakistan. And even the speaker from ADB mentioned a couple of cases in Pakistan as very progressive approaches to environmental courts and tribunals. So I have selected Pakistan as one comparative jurisdiction, and this act of Pakistan has this Pakistan Environmental Protection Act of 1997 and its section 21 establishing environmental tribunals has actually contributed a lot because they have incorporated many international environmental law concepts and principles for the development of environmental jurisdiction in Pakistan. And in Bangladesh, it is very much emphasized on environmental justice prospects. So the Bangladesh Supreme Court has repeatedly demonstrated, and many environmental environmental courts and tribunals under this Environment Court Act in 2000 and the other one Environment Conservation Act in 2010 have contributed. So let me go to the last slide. This is a summary on South Asia. So prospectus wise, I would support this idea of establishing environmental courts and tribunals in other parts of South Asia, which is not currently existing, like Sri Lanka. Expertise, efficiency, environmental justice, and broader approach to alternative dispute resolutions would be some aims or objectives that other parts of the South Asia can consider in comparison with those areas that is currently involved. And also challenges have identified lack of resources, political independency, and also more specific focus on economic and development priorities by these regions have put the environmental agenda somewhere lower in the India governance agendas. And also lack of awareness among the general public on access to justice is another problem when you discuss about courts and tribunals in South Asia. So that is my findings so far. So the research is in progress. So thank you very much for giving me this opportunity. I hope that I manage within the time, Royan. Thank you so much. Ivan.
Thank you, Kokila, for keeping to time. Thank you very much. Yeah, we are sort of running slightly behind panel A, but we are still okay. Thank you. That's very interesting because, yeah, it would indeed have been perfect to have yours at the end because you're doing a sort of comparative analysis with a regional focus, multiple countries, and so on. But on the other hand, Pei-Xuan, who's coming next, is speaking about China, so that's a different geographical location. So in a way, this actually works quite well, and I'm happy to see that you're now thinking about kind of, because this is one of the purposes of the webinar is to get feedback from participants and also from each other and figure out how to best kind of structure our position, our own different chapters. Okay, next up is Pei-Xuan, who was actually scheduled to come slightly earlier, but we just moved her back a little bit. Pei-Xuan, if you can try and have the presentation up on screen. Yeah, I introduced her already, so I'll just quickly just say that she's a PhD candidate in Public International Law at the School of Law, Tsinghua University. The full introduction you've heard already, and her chapter is going to be about ECTs in trans-regional environmental governance, China's experiences and lessons. Pei-Xuan, the floor is yours.
Yeah, thank you, Soryo, and sorry about my poor internet connection.
No worries at all. This is like a part and parcel of online seminars.
Yeah. So I will try to save our time and wrap up in 10 minutes. So my topic is about ECTs in trans-regional environmental governance, and I will share China's experience and try to draw some lessons for China when it deals with the transboundary environmental governance with its neighboring countries and beyond. So here is the background for China's trans-regional environmental justice. China has basically 4 layers of its administrative divisions, and which is the basis for China's judicial system. So you have the National Supreme Court, the People's Supreme Court, and the Provincial Higher People's Court, and the Municipality Intermediate People's Court, and also you have the most basic local People's Court, and some people call it grassroots courts. And as we all know, China is a geographically grand country and with great population. So with the increasing interconnectivity among different administrative divisions and the jurisdictions, there are more and more environmental problems and disputes that are taking place among different cities, provinces, or townships. But on the other hand, the integrity of the ecological and environmental system is the objective fact. So you cannot divide air, river basins, marine environment based on the administrative divisions. But on the other hand, the basic structure, as I mentioned, before the China's court system is based on such administrative divisions, and the causes damage and parties that engaging in the transregional environmental dispute are existing in different regions and jurisdictions. So that comes the problem. And also in one environmental dispute, it may involve civil, criminal, and administrative elements, which makes solving the transregional environmental disputes in China more complicated. So before 2014, there is a severe protectionism by local governments because there is computation of the GDP growth and which sacrificing the environmental protection, and the environmental court and tribunals cannot play a very active role in solving transregional problems. But in 2014 marks the transition of the concept of environmental justice and the role of the court in China. Because the 2014 amendment, it writes, China needs to establish a coordination mechanism across administrative regions for the joint prevention and control of environmental pollution and applying unified plan, standard monitoring and prevention control measures, which means the legislation acknowledging the integrity of the environmental system, and also it noticed the importance of transregional environmental governance. And also this law giving the social groups the legal standing to bring a case to People's Court, and it also has the provisions regarding public participation, access to information, EIA, and it also enhanced the responsibility and increased the penalty for environmental damages. And here I found there are three very important guiding principles that laying the foundation for the ECT's work in handling transregional environmental disputes. The first is the professionalization and specialization of environmental justice. It includes establishing ECTs nationwide and increasing professionals that working on environmental trials, and also most of the environmental court and tribunals, they are merging civil, criminal, and administrative trials into one. And also the principle of green development, green justice, it recognizes the integrity of the environmental system, and it upheld the principle of sustainable development to balance economic, social, and environmental interests. And most importantly, there is a trend in China to delocalize the judicial system. It's to separating jurisdiction from administrative divisions and to prevent local protectionism and its intervention by the local governments. Currently, there are three ways in China that to fund and to operate the transregional ECTs. The first is transregional ECTs based on environmental or natural characteristics. For example, Guizhou province, it established transregional ECT system based on 5 ecological and environmental protect areas. And the second is transregional ECTs in developed areas. So in some provinces or cities, it will place the transregional ECTs in the economically advanced and populated district and endowing it with the jurisdiction to handle cases with transregional elements. And also there are some cities that are trying to using the existing courts that already has the transregional characteristics. For example, Beijing and Shanghai, they are using the court for rail transportations to handle the transregional environmental disputes. And also, I want to mention that the two biggest and longest river in China, Yangtze River and Yellow River, and the ECT system along the Yangtze River is more mature than the Yellow River, because there are more than 1,000 ECTs along the Yangtze River. And also there are many interprovincial and intraprovincial collaboration framework that has been signed. And these agreements usually consist the following elements, such as the cross-jurisdiction case filing and centralized trial for the cases related to cross-provincial acts or damage consequences. And also one jurisdiction can entrust another jurisdiction to for the service of documents, property preservation and enforcement supervision. And also among these courts alongside the Yangtze River, they have established mechanism for sharing information and technology and export pool. And also this court will joint release typical and guiding cases for the protection of the Yangtze River. And finally, they have established a steering group to better facilitate the regular communication among the courts. However, there are still some practical gaps in the transregional ECTs in China, and at least there's 5 major practical gaps. So first one is the jurisdiction is still to a large extent confined to the administrative divisions. So the barriers is not entirely break out. And the second one is the lack of mechanism for assessment and evaluation of the effectivity and the enforcement of the judgment. And also there are too many ECTs in China, and the institutions, trials, standards, and judgments are still very fragmented. And due to the competition among the regions, among different regions for economic growth still exists. So some courts in different regions, they are still lacking the incentives to solving the transregional environmental dispute. And finally, the interprovincial cooperation mechanism is mostly based on the soft framework agreement instead of solid legislation. So we are still lacking a very solid foundation for the transregional ECTs in China. And due to the lack of time, I want to jump into the international side. So we may have some lessons for the transboundary environmental governance from China's experience of its domestic ECTs. So I want to bring your attention to a very important declaration that was concluded in Kunming last year, and which mentioned, especially for the judiciary cooperation for solving the transregional environmental issues. It is that we need to strengthen global cooperation and international judicial interaction in the field of environmental law, and establish and promote mechanism of regular international environmental justice, judicial exchanges, and mutual visits, and build a diversified sharing platform for environmental just judicial cases and judicial experiences to promote mutual learning and sharing, and finally promote a principle of environmental protection and build a community of all life on the earth. So finally, I think there are 2 paths for the ECT's role, or enhance the ECT's role in transboundary or international environmental governance. The first path is to build up the bilateral or multilateral judicial cooperation treaty, or if that's not possible, we can draw a soft instrument on environmental protection. So that may include the coordination of jurisdiction, service of documents, sharing information, and recognition and enforcement of foreign judgment. on the other hand, we can also sign up the bilateral or multilateral treaty on specific environmental issue or related to special environmental or ecological areas. And in that treaty, we can build up shared objectives and stipulate unified standards and set up common mechanism for assessment and evaluation. And that, I think that's the lessons from China's domestic experience for the future international practice with regard to solving the transboundary environmental disputes. So I will end up here, and thank you for listening.
Thank you very much, Pei Xuan, for keeping to time. And yeah, I mean, that's such a big topic, both geographically and conceptually, because geographically, there's this huge area the size of the European Union, essentially covered under one government. And conceptually, there's this issue, as you described, of coordinating between all these different administrative regions and their geographical, environmental, biological diversity. Thank you so much for that summary. I would now, we have about 10 minutes for questions. So if anyone has any questions, please feel free to type them in the chat box. Please also introduce yourself, just your name, and if you have any institutional affiliation. I can see some questions already coming in. I'll slowly redirect them to the panelists as needed. I also have a couple of questions actually, but let's see if we have time for this. But yeah, I strongly encourage participants to come forward with their questions, because this is the whole point of a discussion like this, really, to have a sort of two-way interchange. Or even if you have any comments on the presentations, anything from your own personal experience or research, please feel free to bring that forward as well. Okay, the floor is open now for questions. The first question comes from Clarence Katubig to everyone, to Gertie about the writ of Kalikasan. So Clarence asks, doesn't it effectively give the court supervision and control over an executive body, thereby breaching the separation of powers? This is Clarence from the XU Center for Legal Assistance based in Cagayan de Oro City. Gertie, would you like to take that?
Yes. Thank you, Clarence, for the question. Actually, it's not supervision over what that government agency will be doing, but on the way the project is being pursued. So if the project, actually, example, in the case of the service contract in the Tanyan Strait, our laws provide that you cannot actually do exploration or exploitation work inside our protected areas. So there is a law on that. So if the project specifically violates the law, then our environmental laws, then citizens will not hesitate to, to seek a writ of kalikasan, if applicable, if the damage can affect two cities or two provinces. So there is actually no control over what the government agency is doing. It's basically looking into the environmental impacts of the project. So I think it's very important to stress that since government agencies are required to implement our laws, and we do have a rule of law being observed, they have to be familiar with environmental impact assessments, with our protected area law, fishery laws. So that is the objective. I hope I'm clear. Thank you for the question.
Thank you, Gertie, for the answer. So Clarence has a follow-up question, I think. So it's not supervision and control over an entire agency,
yes,
but rather monitoring a project and ensuring that the court's judgment is enforced. Is that accurate?
Yes. Well said, Clarence. Thank you.
Yeah. Okay. Thank you, Gertie, for answering Clarence's question so comprehensively. Does anyone else have any questions? I think actually maybe Geeta might have something to add from the Indian perspective as well, because separation of powers is something that's often discussed in the Indian context from what I know. So Geeta, would you like to add on your experience?
Yeah, it's a very thin line of differentiation, and India has been, battling with this question: is it proactive judiciary or judicial activism? So, but somehow, within India, the justification of this kind of a monitoring process is being done in relation to to do complete justice. So I agree with that comment that it is about the implementation rather than directing the authorities to do it in a particular way. And there is the element of separation of power or judicial restraint. I can just give one very recent example in 2021. It happened with the NGT. The NGT is responsible for the purposes of ensuring that the laws that it has within its jurisdiction are implemented. And one of them is the Motor Vehicles Act. The Motor Vehicles Act, mandates that you need a pollution under control certificate. So what the tribunal is supposed to do is to look into whether the laws have been implemented or not. But NGT went one step ahead and ordered that if any person does not have a PUC, pollution under control certificate, we are directing that they should not be given petrol from the petrol station. And this is not within the power of the NGT. NGT is only required to look into whether the law is implemented or not. Now, this matter went before the Supreme Court, and the Supreme Court said, you have exceeded the power which has been given, because the power is only for the implementation rather than coming out with an order which says you are acting more as an executive rather than the judiciary itself. So I do agree that there has to be separation of power limits, but then monitoring is a part of it, but it does not include judicial legislation. I hope it answers the question.
Thank you. Thank you, Geeta, Professor Gill. And yeah, I think that's one of the great things about having a panel like this with people who have expertise from multiple jurisdictions, because we get a question on the Philippines and then we see that there's also ramifications in India, and perhaps there's things that we can learn from each other, both as scholars and in terms of kind of capacity building or influencing or lessons that can be learned about setting up ECTs, or about how ECTs can perhaps be made more effective. Do we have any more questions? We've heard from Geeta and Gertie already. I had a sort of a clarification for Peishuan while we are waiting for other questions. So you spoke about the lessons for transboundary environmental governance. So do you think your chapter would focus more on what China can learn from its previous experiences, or what other countries or perhaps the international community can learn from China's current experiences? So is it more sort of internal, or is it kind of drawing on the past to internally kind of influence your present, or is it sort of an inside-out approach where you're thinking about how other countries can draw on China's experience? So what angle do you think you'll take in your chapter? Or maybe it's too early days, I don't know.
Yeah, thank you, Sarong, for your question. Yeah, I think it's very important to clarify the scope of the research. I think there are two parts in my research. First, I will draw from China's lessons, domestic lessons in solving the trans-regional environmental issues, especially when it's related to the river basins. And I think that kind of experience can also inform China's future practice when it's dealing with the transboundary environmental issues with its neighboring countries. For example, we have the shared river basins with countries in Southeast Asia and South Asia, and also the marine pollution issues with neighboring countries. So I think for the international disputes, some people may, for the first instance, think about state responsibility. But sometimes I think state responsibility is very hard to prove. And sometimes if you're resorting to the international court or tribunals, it will be time consuming. So I will also thinking about the private law perspective. That is how the ECTs can cooperate and coordinate in solving the transboundary environmental issues. So that's more about what China can learn from its own domestic experience in solving its future transboundary environmental disputes with other countries.
Right. Yeah, thank you very much. That's very helpful. I just saw a message from Teofilo, but I feel like that's more of a comment, not necessarily directed at or not necessarily sort of requiring an answer. And Gertie confirmed. But basically what Teofilo is saying is if the enforcement is not in accord with law under the Philippines, there's the expanded judicial power of review to stop or preempt the enforcement of the same, and that extends up to the executive department. So that is provided for under the rules of court in addition to what Gertie has said. So, and I think Gertie agrees. So as someone with no knowledge of Philippines law, I'll obviously defer to yours and Teofilo's interpretation. Any more questions? I had a quick one for Kokila as well. Kokila, are you here? So this is just my own lack of knowledge, but what's the situation in, so you said you might do like a comparative analysis of India, Pakistan, Bangladesh, Nepal. I know a little bit, but perhaps there's audience members who know even less than I do about this particular area of the world. So do you have a sense of, like, just at a very basic level, which of these countries have specialist environmental courts? And if not, then how does that fit into the comparative analysis?
Why I chose those countries, India mainly because NGT, but now I will leave that out, and then I will focus on Bangladesh, Pakistan and Nepal, because as far as I know, like Sri Lanka and other countries, Maldives and other South Asian countries do not have function in these green tribunals, these environmental courts and tribunals. So perhaps, I mean, if I share Sri Lankan experience, we use civil courts and also criminal courts, and also from the fundamental right basis, the Supreme Court for environmental matters. So we do not have one unique ECTs as such. So that is why I selected India, Bangladesh and Pakistan, and now I'm moving on to Nepal as well, because I think they are also having some technical framework with the ECTs.
Right, I see. And yeah, I'm sure even if there's currently no specialist court as such, there's probably discussion. Like, for example, in India, I know that for 10 years or 20 years before it was actually set up, there was discussion both at a judicial level and among scholars as well about the necessity or whether it's advisable to have a specialist environmental court or not. So I think that's also a valuable discussion to have for countries which do not yet have one. Is there a discussion or at any level, either among scholars or at the judiciary or the government? Yeah, so yeah, that's
good idea. Yes,
yeah.
yes. I will consider that. Yes.
Yeah, no problem. That's just
That's a good idea.
And yeah, I just saw a comment from Gita on the chat as well, saying SAARC countries' methodology may be used to justify the jurisdictions. So that's sort of in terms of putting a boundary around which jurisdictions you consider. So that could be a sensible thing, a sensible sort of methodology or criterion. Okay, I don't think we have any more questions. I think panel A, which was at one point ahead of us, is now lagging behind. They've just started their Q&A. So shall we take a break? And if people think of any questions or any participants, when I know there was a lot of information to take in, we were flying around all over out of East and Southeast Asia and South Asia. So just have a break, have a think, and if you have any questions, you're also welcome to bring them up in the plenary, which will start in about 5 to 7 minutes. So
can I just intervene? It's just a small comment for Kokila, because when she was talking about Kokila, it's just about the case which you were discussing about the rights of the nature, which the Indian court has done. I think my take on to that is that the Indian courts were not interested in terms of really coming up with an ecocentric approach. I think the judges were more driven by the Hindu philosophy and the Hindu deities, which, are trying to look into the nature. It was just a passing reference which they made in terms of nature be given as the rights. And I think this is one of the fundamental flaws which that judgment has, because what I feel is that the judges have not been able to really distinguish as to when they're talking about the rights of nature, is it a legal entity or is it a legal personhood? So that sort of a debate is ongoing, and it's easy for judges to make a judgment without even understanding what they are talking about. So that's just my comment when you closely read the judgment.
Yes, I would respond to that like this. Yes, I agree with you based on those two judgments by Uttarakhand High Court. But if you look at the broader view of South Asian, Bangladesh is coming up with very good judgments on these aspects. So I would actually take your point into consideration, but I think I would research more into this with the Bangladesh perspective as well, and the broader perspective of South Asian, and also considering the global rights of nature movement that is like increasingly taking into consideration this rights of nature aspect. So yeah, true that the two Indian cases that I referred is has much focus on this what Geeta just mentioned, but I will look at the more broader perspective, Geeta, taking Bangladesh also into the discussion.
Yeah, because what has happened is that the Bangladesh judgments, 2017, 2019, which they're talking about, they are saying that the Indian courts have done it, so that's why we are trying to do this. But in that, they are saying we want the indigenous communities to be a part of it. And that's where the debate is, whether they are talking about a legal entity or legal personhood. And they are just trying to justify as legal entity. And if you look to the countries like New Zealand, Canada, Colombia, they are talking more in terms of legal personhood. So probably, that would be helpful.
Yeah, I will look at the global jurisdictions as well when I talk about this one rights of nature aspect.
Brilliant. Thank you, Kokila. Yeah, I've just been informed that panel A is also over, so we are jumping straight to session 3. Of course, if you need a break, you're welcome to sort of go off and have a glass of water or something, but we are going to be starting session 3 right now, so as not to be too far behind schedule. But yeah, I understand, because speakers have been on camera for a while, so if you need a break, that's fine. But we will start, and we'll start by summarizing panel A and panel B. Okay, so I'll see you in the main room. If you just click leave room, that should take you straight to the main room, and there we can join the plenary. Hello, everyone. Welcome back to the main room. I think our both the panels are over, both the presentations as well as the Q&A. So without further ado, I'll hand over to Matthew, who's already been introduced previously by Linda. So I'll spare you the second introduction. So Matthew from ARIEL, over to you. He's moderating the first session. So yeah, Matthew, the stage is yours.
Thank you very much, Shrayan. And I wish you luck in trying to summarize the panel that was just there. We had excellent presentations that covered such a diverse and fascinating range of subjects, and I thought, I thought it was excellent. So I just want to sort of say thank you so much to all the presenters in that panel, which is panel B, and I'm sure the same occurred in panel A. I must also say that I thought one of the exciting things is just the level of interest and discussion and academic investigation that's going on. And I think that harks back to something that Justice Preston talked about, where we have to actually not only talk about the value of environmental courts and tribunals, but really investigate, are they performing? Are they doing what they need to do, especially as we confront the crises that we see in the environment and society around us, and that we know are not getting any better. the use of environmental rule of law is one of the tools that we want to use. So we have to make sure that our environmental courts and tribunals are very much fit for purpose. And I think, Professor Gill, you highlighted that in terms of the some of the presentation and the questioning about, this power of sumoto power, which is often exercised by many jurisdictions. We don't have that in Australia. We don't have continuing mandamus in Australia that they do in the Philippines. We don't have the writ of kalakasan. But there are these, this is where this opportunity for comparative law and research is being very, very, very interesting and exciting, and hopefully will give us some tools to really change and protect our environment. So anyway, I just wanted to say it was really an exciting panel, as you can tell. But first, if I could turn now to Briony and Briony Eales from the Asian Development Bank. And I don't do it, Briony, but if you're able to do a quick summary or key messages from panel A, please, the screen is yours. Thank you.
Yeah, I don't know how I'm going to do it either. I'm hoping something will come forth, but my brain is full. And I think, so we had really 4 fascinating speakers, Linda Sulistiwati. I'm so sorry, it's late in the evening for me here. Associate Professor Yuhang Zhao, and Professor Noriko Okubo and Alan Webb from New Zealand. And what really came through, the focus of the different sessions that we had was really Linda providing an overview of what's happening with ECTs globally and the growth in them and the benefits of them. And she drilled down into 2 really significant jurisdictions, being India and the People's Republic of China, and their use of ECTs and those jurisdictions and how they're working. And then she also looked at jurisdictions like Indonesia, Thailand, and the Philippines, that while they don't have specialized they don't have green tribunals or courts, they have specialized judges, and there's really a focus on how they train the judges to be more receptive. As Linda highlighted, what makes the PRC such a fascinating and important jurisdiction is that since, I think, 2016, there's been a growth of 1,500 ECTs established, and Associate Professor Yuhang Zhao was able to explain and drill down more into what the jurisdiction has been and how those courts have been functioning. But first, let me just move to Professor Noriko Okubo talking about the Japanese ECTs and the fact that there's no specialized environmental courts in Japan, and that's prohibited by the Constitution. But what has grown up in its place are environmental ADR procedures, which have been fascinating and have allowed for this flexibility around standing and getting parties to come before these ADR processes that appoint technical experts. And I think a couple of the things that she described were a great degree of independence and transparency, and the capacity of these ADR processes to overcome some of the rigid rules related to standing and remedies, which in 2022, we can't wait 8 years to get a resolution, and damages don't always cut it. So this was a really important aspect to hear about what's happening in Japan. Moving to the PRC, Associate Professor Yuhang Zhao looked at the creation of the ECTs and why that happened, and how that really happened in a response to economic development at the expense of the environment that was damaging communities, and how people responded. And the fact that even though there were hotlines and letters and people were making over 1,000 complaints a year, it wasn't resulting in litigation. And so she talked about what the ECTs are doing and how they're facilitating easier access to justice by victims. Again, this issue of timely redress and improved quality of judgments. And that seems to be coming about because judges in the ECTs must have unique a unique attitude and passion for environment. And I think that comes back to what Justice Preston was talking about. Judges always have a leeway of choice. So where we have judges with this skill and passion, they can exercise their leeways of choice within their jurisdiction to create better decisions. Now, each of the speakers did highlight some of the difficulties within their jurisdictions. I'll just move to Alan Webb, who talked about in New Zealand with an environmental court that has been set up since the 1950s. It's one court with 3 bases in Auckland, Christchurch, and Wellington. And all judges have to be prior practitioners, and there's a use of judges and commissioners to bring in that specialized expertise. Some of the one of the issues that Alan highlighted was one of the critical issues that the New Zealand court looks at is permitting for council plans or projects, and how that can sometimes take 12 to 24 months. And he said that that was something that needed to be addressed within the system. So I think that's really it. I've kind of blown through everything in a nutshell, but what I really did want to stress is that what we're seeing in 3 jurisdictions are these courts being set up to help the average person come to court and access justice. So the relaxation around rules of standing, and then more flexibility around responses. And I think that those are really critical things to focus on. What I would like to see in terms of authors when they're thinking about it, and how ECTs can overcome challenges. What are their challenges with enforcing judgments, and how are they overcoming it? And how does that create constraints to ECTs being effective, but then also what are they doing well? So that's session A. I'm really sorry to all of the presenters if I missed anything critical, but that's it in a nutshell.
Thanks, Briony. And we, of course, will be having a book that will come out, so there'll be plenty of opportunity to dive deeply into some of those topics. So I'm going to restrain myself and then just ask Dr. Shoyan Mukherjee if he would like to try and provide a bit of an overview on panel B. Can I also please ask people if they want to ask a question to type it in the chat box, because we will have some time for some moderated question and answer and discussion after the presentations. So Shoyan, the screen is yours.
Thank you, Matthew, and thank you, Briony, for that excellent summary. I'm sorry to have missed panel A, but then I would have missed panel B. So it's either the one or the other. Okay, so panel B had four talks like panel A. So it was about 1.5 hours, and I felt like there was at least like 3 hours worth of discussion, analysis, and energy in there. So it could easily have gone on for twice as long. And now I have the enviable task of condensing it down to about 5 or 7 minutes. So let's see how it goes. I'll take it in a slightly different order from how it happened, but it's also helpful that Briony talked about panel A already, because some of the issues I think are common across these jurisdictions, as indeed you would expect, and that's going to be one of the interesting things about the book, I think, in terms of how the different areas where they overlap and also where they differ, right? So what the because they're in a way they're similar, but in a way they're very diverse as well. So I'll revise the order slightly. I'll start with Professor Gitanjali Gill, then move on to Professor Kokila Konasinghe, because these are both from South Asia, and then moving upwards and eastwards, eastwards rather, I'll summarize Gertie's presentation, Griselda Mayo-Anda's presentation about the Philippines, and finally end with Pei Xuan, who spoke about China. Professor Gill talked about the National Green Tribunal of India, or the NGT. So essentially, it's the in terms of an overview, she divided it into 3 phases. So the first phase, 2010 to 2012, I think this is a really helpful way of understanding something that has a relatively short but actually quite a complex history. So the first phase, 2010 to 2012, I would say was summarizing our presentation, it was characterized by teething problems as well as a degree of hesitance and resistance. 2012 to 2018 was the golden phase when there was substantive expansion and procedural innovation about things like standing, access to justice, in-house expertise, because the NGT has experts, environmental experts as well as judges, so it's not just legally trained judges, and stakeholder consultation. So a number of things, so a number of innovations, both substantively and procedurally. Then 2018 to 2022 seems to have come full circle again, with some old problems resurfacing or some new problems surfacing, and the focus in this part was very much on the enforcement of orders. So the past orders, how effective are they? And this goes back to the point about enforcement that Briony was also talking about, and how could enforcement be improved? What is the court's role, and so on and so forth. Gita's presentation ended with the assessment. So assessment in the sense of the NGT being a role model for developing countries and having an international reputation, but at the same time also acknowledging the challenges, that there's a limited bench about the quality and reasoning of orders, because that, from what I understood, seems to have not been consistent down the years, and finally some reservations about the exercise of suo motu power. So that was Gita's presentation. Kokila's presentation was about South Asia in general, and it was so essentially about why have ECTs in the first place, the importance of environmental justice, which starting with Justice Preston, all the various speakers have emphasized, and the need for equity in the distribution of environmental risks and commitments. So very important for a comparative project such as Kokila's is the recognition of the diversity of the participants and the experiences in the affected communities. So this is not just nationally, like within those countries, but also internationally. When comparing between different countries, we need to recognize the diversity of the participants and their experiences. She also alluded to the rights of nature and recognition of legal personhood. So that's sort of a topic which has come up in various jurisdictions as well, not least New Zealand, which is also one of the chapters in our book. And finally, the significance of South Asia, right? So there's very specific challenges, so environmental challenges, pollution, deforestation, and its susceptibility to the adverse effects of climate change. And Kokila ended with some thoughts or ponderings on which countries, and that's actually a discussion which carried on to the Q&A as well, in terms of which countries should to cover and how best to avoid overlap with topics which Professor Gill is covering already in her chapter on India. So other South Asian jurisdictions such as Pakistan, Bangladesh, Nepal, possibly according to the SAARC countries, and so on and so forth. So that was Kokila. Moving on now to Griselda Mayo Anda, known to many of us as Gertie. So she talked about opportunities in the Philippines. As a progressive constitution which incorporates the right to a healthy and balanced ecology, designation of environmental courts, public interest law groups and human rights organizations are quite active. So all that paints quite a positive picture in terms of there being opportunities in the Philippines for environmental litigation and environmental courts in particular. Then she outlined the legal and policy framework, as well as the constitutional provisions which incorporate the right to a healthy and balanced ecology, the Supreme Court rules of procedure for environmental cases. She talked about citizen suits, which have been a prominent feature of Philippines environmental law, the right of nature, kalikasan, about which we had a couple of very interesting questions as well, and the writ of continuing mandamus. And finally, she described a couple of very interesting case studies. One was the resident marine mammals case and the Boracay Foundation case. So these two cases, and then she tied them in with various strands which she had introduced within her presentation as well. So that was Gertie, and coming finally now to Pei Xuan, whose talk was about ECTs in trans-regional environmental governance, China's experiences and lessons. So she talked about the background of trans-regional environmental disputes. So China, as you can imagine, as we all know, is obviously a very large country, a diverse country, and I think what the takeaway for me from Pei Xuan's presentation was this tension, right? The tension between administrative and regional divisions, which are needed as a matter of administrative expedience, versus the interconnectivity, because as we know, on a global scale, a lot of climate change, a lot of environmental problems, most famously climate change, is an interconnected problem, and that obviously applies to a country as well, especially to a country as large and as China. So problems are interconnected. A river from one administrative division flows into another administrative division. So problems are interconnected, but sometimes the solutions are split up into diverse administrative and regional divisions. Pei Xuan talked about the 2014 amendment of the Environmental Protection Law, and she described it as a turning point, establishing a coordination mechanism across regions, unifying standards and controls. And so she gave an overview of the guiding principles in transnational environmental justice, and also referred to some practical gaps that continue to exist. And finally, she talked about the lessons for transboundary environmental governance, specifically with reference to the Kunming Declaration of the World Judicial Conference on the Environment in 2021. So I think there's many strands to unpack, and I'm really looking forward to reading the chapter. But so I'll just pick out one, because there was quite a few she discussed in terms of practical gaps as well as lessons. And one of the things Pei Xuan suggested is about bilateral or a multilateral judicial cooperation treaty, very interesting proposal, or a soft instrument on environmental protection. Or alternatively, so this is a judicial cooperation treaty, but alternatively, there could also be a bilateral or multilateral treaty on specific environmental issues or areas. So that's some of the lessons that we can draw from sort of China's checkered history and experience in terms of managing trans-regional environmental disputes. That was my attempt at summarizing a 1.5 hour long discussion. Apologies to the presenters if I missed out something important. I hand the mic back to Matthew, and we can if there's any questions or clarifications, maybe the speakers can also step in during the Q&A. Thank you very much.
Thank you, Shoryon. That was exceptional, I have to say. It was a great summary, and highlighted some of the really interesting potential for research. And I thought, hearing Briony's comment about Professor Zhao's judicial response to environmental crises, and hearing some of China judges talk about not only the creation of the environmental courts and the tribunals within China, but also the growth of what is called public interest environmental litigation. And then hearing that comment about the idea of multilateral cooperation on cases. The interesting thing I find is, of course, the idea of cross-jurisdictional dispute resolution is very well known in private sector arbitration. And I know, Shoryon, from your, and Briony, from your, previous incarnations in the commercial field, multi-party, multi-jurisdictional commercial arbitration is something that companies, the private sector, engages in quite regularly. Often, of course, if there is an environmental issue, it might be excluded. And one of the things I find fascinating is how we can bring in some of these environmental issues and environmental stakeholders in terms of some of these other commercial arbitrations. And I'm thinking about Belt and Road arbitrations or major infrastructure arbitration. So I do think there's this whole opportunity for developing an interesting approach to dealing and resolving environmental disputes that may not just be through a specialized environmental courts and tribunals, but may also be using some of these existing dispute resolution bodies that to date have often excluded environmental issues or social issues, but we now know that they're interconnected and need to be resolved. So I thought that was also really quite an interesting approach. I'll certainly take up Shoryon's opportunity. If anyone wants to raise their hand, any of our speakers want to raise their hand using the reaction button, we can then allow you to make a comment or an observation. I think we do probably have maybe 5 or 10 minutes, depending on which schedule. I'm for anyone to raise a question or even type it into the question and answer box. Did anyone want to raise their hands to sort of ask a question directly or make a comment or an observation? I'm looking in the participants box. Is there any comments? I mean, Briony, I guess, one of the questions I'd ask, maybe I would put this back in terms of some of these ideas for international or regional, multinational cooperation or agreement. Is this something that you think has potential? You mentioned the Pacific. I mean, is it something that maybe in ASEAN we might see some movement to deal with environmental disputes on a regional basis, or is this something that is unlikely to occur in the short term?
Well, it's going to take time, of course, because setting anything up by consent of different countries is going to take time. But I think there's greater recognition of, particularly within global frameworks, about the need for cooperation and collaboration. And so many of the new and emerging, I mean, I shouldn't call them new, but emerging environmental issues are transboundary. And we need new ways of addressing some of these transboundary issues that will start to emerge. So people are going to start moving as a consequence of climate change, and we don't really have consensual mechanisms in place or ways to resolve those kinds of issues. So I think it could be a great way for there to be mediated agreements in some of these big disputes that are transboundary, to take into account and hear from multiple different stakeholders. And that's one of the limitations, I think, of the arbitration system currently. Many disputes, as you say, are arbitrated without looking at the environmental issues, but they also don't invite into the process or make it transparent for affected communities. So we need to have processes that communities and governments, local governments trust, that enable all of these different parties to be involved. So there is potential for these cross-boundary or these regional dispute mechanisms to start assisting with governance and just reaching agreements on how people collaborate. I mean, that's just me thinking out of turn, and I'm happy to hear comments from anyone anyone online about that and to further that discussion. But those are some of the things that I can think immediately would be quite powerful.
Thanks. And Sharon, one interesting thing is that in that panel, we had 3 different legal systems. We were talking about common law legal systems, code legal systems, and hybrid systems, which perhaps we could call the Philippines and Indonesia a bit of a hybrid system. I mean, do you think this is an issue that is going to be relevant, or have we reached the point where the structure of the tribunal court is of less important as its power, its functions, its processes, and its procedures in resolving disputes? Or do we still have to go back and think about that source of law and where the law is coming from?
Yeah, that's an interesting question. I guess it also depends on whether we are talking about the judgments themselves or about the setting up of the courts, because the judgments themselves may be quite different depending on whether it's a common law, civil law, or a hybrid jurisdiction. But the considerations for setting up a specialist tribunal, or in the case of India, for example, the considerations in terms of whether you're only going to have legally trained judges, former lawyers, former judges on the panel, or whether you're going to have experts as well. I don't think those are super influenced by whether it's a civil law or common law jurisdiction, but I don't have much experience or any experience really in civil law, but I've also been reading literature about sort of how these divisions are kind of collapsing slowly. You have the case of the EU, for example, and the ECJ, which incorporates both civil and common law jurisdictions, and it's perhaps getting so what traditionally used to be considered civil law is maybe becoming a bit more like common law, and vice versa. So I'm not even sure how much but it's something to think about for sure. I think it goes back to what I was saying earlier about the jurisdictions being different, but also having certain things in common, and that's really interesting tension to explore in the book and in the various chapters, I think.
Thank you. So I just, we have a comment from Professor Gill, and I think very important in terms of the issue of arbitration, which is a private party dispute resolution process that often uses a private mechanism. It doesn't use the court. It uses an independent or a party appointed arbitrator. And it is those questions that marginalized voices are not heard effectively, if at all. And that's clearly one of those issues about arbitration and those private law processes. I did want to just also mention www.ajne.org. I put that in the website, which will take you to the 4-volume reports that Briony co-authored. And one of the reasons I also want to do that is, A, there's a lot of amazing references about climate litigation, but B, there's an extraordinary depth of scholarship on constitutional issues, because that's also one of the interesting issues that all of us, I think, have discovered, is that environmental law often does revolve around the interpretations of constitutions in terms of whether it's India or Sri Lanka or Bangladesh, the Philippines, constitutional provisions and the various rights granted under constitutional provisions do play a very significant role in environmental litigation. So, Briony and Cecile did a very good deep dive into reviewing and looking at some of the constitutional provisions, not just relating to climate, but relating to a whole range of other environmental rights. So that's a bit of a plug. If you go there, you can download all 4 volumes. It's only a short 1,100 pages, so good bedtime reading. But we're looking for the update coming out soon, Briony. So I have a question from Linda. She's curious about the prospects of countries without environmental courts and tribunals and not putting environmental case resolution as a priority. How do we encourage them? Well, that's a good question. Any thoughts from our commentators, or indeed any of our panelists who might like to turn on their cameras and provide a comment? Briony, can I?
Oh, wow. It's really such a great question. And often it seems to be when a country starts reaching higher levels of economic development and people aren't so worried about just putting on their food on their plate every day, they can start thinking about other issues. But I think one way that could be quite effective is in supply chains and in multinational corporations. I'm not saying the good guys, but we have seen often these big corporations are regulated by stock exchange rules or legislation from their home country that puts obligations on them, or they get caught by obligations within supply chains. So when they come to operate in other countries without ECTs, they do have some of those standards that are set on them. That's just one idea. I'm not suggesting that I have all of them, but I think in many countries, people are starting to realize that is central to sustainable development, and central to development is the environment. I mean, you can't operate your way out of environmental collapse. You can't grow your way out of climate change. And I think as some of these impacts are becoming, more pressing, the countries are starting to realize that this is something that they have to address. So there are two ideas. I'm sure other people here have great ideas around this.
And I did notice Elizabeth Wu was in the audience. Client Earth is an organisation that I know has been conducting litigation against companies to require the companies to engage in more of their sustainable and I think as ESG, as Professor Gill has mentioned, is a new. I wonder if it's the new bright shiny toy that everyone's focusing on at the moment. Although I am delivering a presentation of the Singapore Law Society about ESG, but I approach it very much from the safeguards point of view rather than the reporting point of view. But that's also an interesting opportunity, I think, for us to think, which also explains, I think, some of the comments that people have made in terms of the role of judges in environmental courts, but the argument that we are all environmental lawyers, that corporate lawyers have to start putting the environment before the profits. They have to start advising their clients in those ways. And that also will probably see a change in both the litigation and therefore the role of environmental courts and tribunals, hopefully with specialised courts being able to make better decisions than corporate or commercial courts making environmental decisions. Briony, yes. Sure.
Yeah, just picking up on exactly that point on the ESG, that's, as you say, you look at the safeguard side, but the reality is, you have organizations around the world looking at directors' duties. You have the Commonwealth Law Initiative getting advices from prominent barristers in different jurisdictions about liabilities. So, when you pull some of those levers and you create a demand for it within the community and the environment, that does start putting pressure on government, because stakeholders are going to them and asking for these things. And as you say, you made such a great point about Client Earth, and you also made a great point about constitutional rights. What we've seen in Asia and the Pacific, really relatively new constitutions in many cases. And in about 75% of cases, I think, we see constitutions that have been passed after critical UN or international treaties like the ICCPR, or in particular the Stockholm Declaration. So these constitutions have picked up on these environmental human rights, and they are effective tools for citizens to use in any of their courts. You don't have to go to an environmental court. You can go to whatever court has this constitutional jurisdiction to bring this in case around environmental rights. So it's just a matter, I think, of that, the ECT may not be there, and we recognize it's great to have it, but when people are suing or they're bringing these actions on the available hooks, and you start getting the demand, that really does then put pressure on courts to respond.
Thanks. Troyan, did you want to have a final comment before I hand back to Linda?
No, I think I'm okay. I'm not sure if Linda's still online. Is she?
Yes, I'm here, Troyan.
Okay, yeah.
So first, I'd just like to thank Briony and Troyan for being able to summarize those things, and also the presenters again. Can I say that, just on behalf of the Asian Research Institute for Environmental Law, we are very excited by the discussions that this project has generated, the great work done by APCEL and University of Ghent in terms of the updated materials that are going to be launched, I think, on the 1st of September. There is a lot of excitement. There's a lot of great scholarship, great research being done. The exciting idea that we have here, of course, of bringing it all together. The book, I'm sure, is just going to be one of the vehicles, but the opportunity for more workshops, for more presentations, for more discussions, I think is also very, very exciting. And I will, on that note, hand it back to Linda and say thank you. It's been a great pleasure to be part of this amazing event today. So thank you.
Thanks, Matthew, for the excellent moderating, and also Briony and Shoyon for the hard work in such short time. I really don't envy both of you to have to do that. I'm amazed by the all the accumulated knowledge that we have during this short time of our webinar. We talked about upstream issues and downstream issues of ECTs, judges training, non-state actor, government support, environmental jurisprudence, and court support, and covered many geographical areas from Australia to the Pacific, from Japan to India and China, what have you. But is this enough though? It's not enough, because all of it will be detailed in our book, our coming book in 2023, entitled Environmental Courts and Tribunals in Asia Pacific region, published by Brill, hopefully. I would like to extend our deepest gratitude to ADB in ARIEL for the hard work, together with APCEL, putting together this event, this webinar, and also for our panelists, our authors. Thank you very much for your ideas, your hard work in your framework for the article for the book, and we're waiting for your draft for the book in February 1st, 2023, so that we can produce the book and later that year. So I think we have overrun all of your time enough, and all the participants that are here from the beginning until the end, thank you so much for your engagement. This is very important for all of us to put our ideas out and get feedback from all of you. Thank you so much, and from APCEL, and we hope to see you again in our future webinar. Please scan our QR codes or click the link in the chat box for your feedback to this webinar. Thank you so much. Good afternoon, good day for all of you. Thank you, and selamat sore.